Okay, this is the Sunshine Ordinance Task Force on Wednesday, November 6th at 4:11 p.m. We're going to call the roll. Yeah, please call roll.
Member LaHood?
Present.
Member LaHood present. Josh Wolf, not present. Rishi Chopra, not present. Lawam Tesfaye?
Present.
Lawam Tesfaye present. Member Martin?
Present.
Member Martin present. Member Highland?
Present.
Member Highland present. Member Yankee?
Present.
Member Yankee present. Member Hensy, not present. Chair Wolf?
Present.
Chair Wolf present. We have a quorum.
Trying to find this paragraph that I'm supposed to read here.
You want me to announce the agenda changes?
Yes, please.
We have an agenda change to today's hearing. Item number 6, file number 19018 will not be heard. The petitioner asked to withdraw her complaint.
I'm just trying to find that passage I'm supposed to read now that we passed at the last meeting.
Template.
Yeah, it's not in the minutes.
I'm gonna put it on the cover sheet. No, we're gonna read it. Is that what we decided?
I have last week's minutes here. Last month's minutes.
Whoops. All right.
Just a moment. We have a new procedure. We're just trying to find the right passage.
Bottom of page 7, in the meeting minutes.
Page 7. I don't see that. Am I reading the
Number
right
10.
minutes?
Number 10.
Hold on. Make sure I got the right minutes going. Oh, okay. I got it. Okay. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. That's how we're going to be starting our meetings now, after a lot of discussion.
Would you like me to add that to each agenda?
Yes.
Okay.
Okay.
And that was item 10 from the October 2nd minutes.
Yeah. Need this. Yeah, next item, please.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force October 2nd, 2019 meeting. Any changes?
Sure. That was actually me, surprisingly. Number 2 asked for the corrections, not Member Martin.
I'm sorry, I didn't hear that.
I said that was me who requested the changes under item number 2 and
Yes.
made the motion to approve.
You made the motion?
Yeah. And then item number 10, that was actually, I believe, 2 motions. We made an original motion to approve the language, and then we made a motion to amend it. So I believe if you go back to the audio, there were 2 motions.
Item number 10, okay, hang on.
Yeah, bottom of page 7.
Review audio.
That's it.
Are there any other changes or adjustments to the edits to the minutes?
I'll move to approve then.
Oh,
Okay.
go ahead. And is there a second?
I'll second.
Moved by Member Yankee, second by Member Martin. Any public comment on the minutes? Seeing none, can we take it by acclamation? Seeing no objection. Let's call next item, please.
Item number 3, file number 18083, complaint filed by Robert M. Smith against the Fine Arts Museums of San Francisco for violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner. Mr. Smith? Mr.
Yes, I'm here.
Okay, can you hear us?
I can hear you.
Okay, great.
I can hear you personally. I don't know about the rest. Yeah.
All our microphones are on. Are you not hearing Bruce Wolf or Luam Tesfaye?
When somebody says something, I'll tell you if I'm not. But I can certainly, I hear you. I
Okay.
hear you fine.
All right, great. Thank you very much.
Before we start, I have a question. In the beginning of this file is the order of determination.
If there's an order of determination, that's the first thing we put in. That's how I've been trained, to put that in there.
This is a new case.
No, it's a 1988 case.
All right, let's proceed. I'm a little, this says, okay. This is a 2019 case.
2018.
It was
18083.
adjudicated in May. According to the order of termination, it's adjudicated May 1st, 2019. It's just a little odd to see an order of determination list. This was a reconsideration.
Looks like the staff notes show that compliance and amendments sent it back.
Yeah, it's bounced back
That's
to
what
us.
it says.
Oh, so this
On
was
August
a
27,
return
the
back
compliance and
from
referred-
committee?
Yeah, and it goes
Okay.
back to 18 originally, I believe.
Okay, got it. Thank you. Just want to make sure everybody's clear on where we are here. Okay, okay, so this has been referred back. So this doesn't demand our regular process. This is now with the task force to determine how to proceed forward. Compliance, and it seems like, is anybody here from compliance and amendments?
No,
that can speak
Kanata
to
and
this?
Heinz. Okay.
I believe I was at that meeting, and yes, the museum has not complied with our order of determination.
Okay.
Is this the Muslim outfits
Yeah.
hearing?
Yes, that's correct.
Okay. So, so was there a recommendation from,
To send
Right,
it back
so
to the full task force.
okay. All right. Okay. Is the respondent here? Can you approach? So the task force is asking why there still hasn't been compliance.
Well, our response was that we had produced the requested records, and
Can you speak a bit more into the microphone? if possible?
sorry,
Yeah, thanks.
our response in
State your name, please.
oh yes, Megan Bourne, Fine Arts Museums of San Francisco. So our response in at the August Compliance and Amendments Committee meeting was that we had produced the requested documents.
Okay. Lila, Member LaHood, do you recall what?
I don't recall the exact details. I mean, hang on. Let me look at the notes.
Okay, appreciate that.
It was a long and complicated conversation.
I'm sure. That's why
Yeah,
I want
yeah.
to make sure we're all on the
Yeah,
same
it
page,
was.
'cause-
So it looks like it was about the redactions, and that there was not sufficient there was not sufficient explanation of the redactions.
Okay.
So, well, that was on the, looking at the minutes from the Compliance and Amendments Committee meeting, that was the discussion about matter 18049, which is also next on tonight's agenda.
Right.
No, there's no timing, because we're bringing this back for, to determine this. This is an open process for this particular aspect. This is more or less a report back from Compliance and Amendments regarding the monitoring of the order of determination. The order of determination has not been fulfilled according to the committee. The committee's making a recommendation to refer it back to the task force for further action if necessary.
So you're right. I was referring to the other one. This was that Mr. Smith said he had only received a few non-substantive documents and that he had not received everything he had requested.
Okay. Do we know what's still missing?
Can we ask Mr. Smith?
Sure. Mr. Smith, are you there?
I'm here.
Okay, can you tell us what is still outstanding?
Well, sorry if I'm a bit boggled here. May I just say preliminarily, just so we're on the same page, the task force committed some long time ago to having all three of these matters heard at the same time, which I think would be helpful to everybody. But that didn't happen here, and the clerk says it's because she was on holiday and wasn't aware of it. But I'm hoping going forward, the task force will honor its commitment to have three matters heard at the same time, which really would be helpful, including in this question. As to what's missing, I made a presentation about this to the Compliance Committee, and they found that the museums had not complied. And basically, I can't tell you, to be honest, what's missing because they refuse to produce documents and refuse to disclose what it is they are not producing. So nobody could tell you what they haven't produced because they're not saying what they're not producing. They just say, we're not producing something. I don't know how many things. I can't answer the question honestly.
Okay, Mr. Smith, the only way that we can move forward is if somebody makes a request for records and then are denied, knowing that the records exist, and then if they're denied those records, then we have something to go on. We can't go on to determine whether records exist or not. We can ask, but we don't have like subpoena power to be able to compel in that way. I mean, we do have the authority to compel, but not, and it's to a certain extent.
We're in a different circumstance here. I understand what you're kind enough to explain.
Yeah.
They are saying that in terms of what they have been required by law to produce, they haven't done it. They have withheld documents and won't tell me what documents they have withheld. So there is no question that they were properly sought, but I can't, and therefore they fit your parameters because I asked for them. They acknowledge they were requested and required, but say they didn't furnish them, but won't say what it is they wouldn't furnish. Now,
Okay.
surely that's within your ambit.
Okay, let me ask the respondent a question for the museums. So, based upon the request, you're withholding certain records. Is that correct?
It is correct that we have, as we have talked about in every time we're here, we have the Fine Arts Museums of San Francisco and the Corporation of the Fine Arts Museums in the same building and using the same email server. We believe that we have produced all responsive FAM-SF documents.
May I speak? I obviously can't see what's happening there, but
All right.
that's the issue. That is to say, has the task force, after a year and a half, reached a determination that the records on shared servers, that is to say, all of these documents are on servers that are accessible to and the property of the museum, as well as this agency to which it is asked for and paid for help. Are those not susceptible lawfully to being turned over as public records? We can't go on for another year and a half on this issue, I respectfully submit.
Is that true, that for all three entities, that you're all on shared servers?
Correct. Which are actually owned by the Corporation of the Fine Arts Museums.
Yeah, but you have, if the city agency has access or to any of those, then they are custodian. They become custodian of those records. Become public records at that point. They must be produced. If somebody sends a document by accident to the city, it becomes a public document. Because it's in possession of the city.
Well, that's the first. That's the first time I've actually heard that specific interpretation, which I think is interesting. And I will say that I agree with Mr. Smith that over the just about a year that we've been going through these, it seemed like we were moving towards consolidating these three matters into one discussion, and it does seem that the unresolved question is, what's
the status between the three entities with regards to public disclosure,
Yeah.
and public
Yeah.
information?
Yeah.
Well, here's the thing. I think hearing this is the kind of the first time I've heard, in my recollection, that all the documents there are many documents that are shared between the three entities on the same, however it is, same file cabinet, same desk, same computer, or what have you. And if that's the case, and those documents are being used in the course of the people's business, they're publicly information. The only thing prohibiting their disclosure would be some citation of law that would exempt them either from being disclosed completely, like in the case of an investigation or something like that. Otherwise, certain information on it could be redacted, only with some citation of law allowing for that. So it's a very interesting kind of set of circumstances before us right now. Member Highland.
Just reaching back, 18 months this has been going on. My understanding is that we went back and we had the whole discussion about the silos. We then asked the memorandum of understanding, the MOU, to be produced. We looked at that, and I believe we determined that, as Chair Wolf just said, anything that hits your silo becomes a public document. Now, I wish that language had been reflected in the order of determination, and maybe we should have included that in there, but I'll read the order of determination in this matter. It's pretty vanilla. It just says, on May 1st, 2019, Member Kanata, second by Member Hensley, moved to find that the Fine Arts Museum of San Francisco violated, et cetera, by not providing the requested documents timely and complete manner, and for not sending representatives to hearing. So that's what we're working from, and that's that's latest. I thought this hearing was more about the fact that, okay, you have provided documents and they're overly redacted. I thought that's where we're
That's
going
the
to.
second
that's the
item.
second
That's why
one.
this is
Okay.
getting
I'm
confusing.
conflating
We've
the
had
two.
these conversations multiple times.
Okay.
Could I speak to the May 21st side? I have to double check, but I believe on that complaint, one of the aspects of it was that we did not attend the hearing, and that was in fact the case. The two people on our staff, now it's just one person, but we had a longstanding museum commitment on the night of that hearing, and we couldn't make it, and we were denied the opportunity to appear at another time. So that we accepted that finding.
Okay. I mean, you were forwarded these results, and based on this order determination, should then have produced everything that was in the original requests, correct? I mean, this was our order determination.
I'm not sure about that.
I just want to clarify something. In the minutes for the Compliance and Amendments Committee, the motion was moved by Member Hinsey, seconded by Member LaHood to refer the matter to the task force review of the extensive redactions.
This is the other item.
But this is the 18083, and that's the item that we're on now. That's what's on the agenda.
18049 is the extensive.
Okay,
Yeah,
all right,
the other item.
okay,
The next item.
all right.
The 18049 is Mr. Smith's first complaint.
Okay,
Kind of could have heard them all together.
hold on, I'm sorry.
May I try to be helpful here?
No, please, wait.
So if you read in the meeting notes, if you read the first one and the second one, they're in the same order as the items on the agenda, but it's confusing because it looks like they're all part of the same conversation, but these are two separate pieces.
No, I'm looking on page 3 of the minutes from the Compliance and Amendments Committee. Okay, the action there talks about extensive redactions in the minutes. Is that correct?
That's pertaining to 18049.
I'm asking the task force, if you don't mind. Thank you. I just want to know which case is which. And it's hard to combine some of these cases like that because the violations are different. And so though each of those violations have to have their own, should be heard independently because they're extensive. Vice Chair Joshua.
I think what you say about each of these cases needing to be handled independently is completely valid, but among all of these cases is the overarching question of the relationship between these entities and what is actually a public document. And I'm curious whether it makes sense to just look at that first in some fashion and then use whatever comes out of that to guide the rest of the process.
Well, we haven't gotten through the bottleneck of the three-entity relationship that that I think needed to come from our legal counsel's office.
Right, but I guess I feel like until we push through that bottleneck, all this stuff is kind of jamming up because that'll clarify all of
Well,
the
actually,
other
I think
pieces.
what I mentioned before actually clarifies it. I mean, I think Mr. Smith, his statement and the confirmation from the respondent that there are shared files between the three entities, that if the city agency who has a responsibility under Sunshine has possession or access to those documents, and they are public and should be disclosed, and if they are meant not to be disclosed or parts of it are meant to be redacted, then there has to be some citation as to why.
So we've established that even though the documents are shared on the same server, that the city has access to the other side of that?
I just am stating that. That's up for us to determine and to ferret out. If we believe that to be the case, then we may want to take action based upon that.
Through the chair, can we ask the respondent to clarify that access?
Be my guest. Sure.
Excuse me, so do employees of the city have access to the files that are maintained by the entity that is not owned or operated by the city?
I'm not sure that I can give you the absolute accurate answer to that without going back and looking into who has what access on servers and email. I would say in the broadest sense, no. There are some areas where, because we have pretty discrete sectors of city employees. So security officers is the majority of our employees, engineers, and so I would say that for the most part they are only discussing the city business. In the case of the engineers, they probably have some access to other documents pertaining to the maintenance of the buildings, because COFAM participates in the maintenance of the buildings also. And then we have, kind of our HR is segregated. I'd say we have 2 curators in the Achenbach who are city employees. They're the only city-paid people in the art division, and they would have access to some documents pertaining to the collection and to the business of the art division.
Okay, well, reducing this down one layer further, and you're probably going to potentially need to consult with someone. So FAMSF is the city entity, right?
Correct.
Does FAMSF's data structures, macros, entities that have been programmed have access to the data sets contained on the server and maintained by COFAM?
I would say generally not, but I would say that there are likely some exceptions to that.
Would you be able to, at a later date, map out both those exceptions and the access that all employees of FAMSF have in regards to access to data and data sets held by COFAM?
I think so. I mean, I could certainly take a pass at it and see how it works for you. So
that's a start.
Yeah.
Great. Thanks.
Yes, so I have located and cross-referenced from the original minutes to the meeting notes here, and I think this is where there's some confusion. If you look for each of these items, there is, for the first one, there are comments that come from a May 1st meeting and then an August 27th meeting. For the second one, there are comments from a March 6th meeting and then from an August 27th meeting. In referring to both August 27th meetings, these are both about excessive redactions and an incomplete privilege log.
So it's not about receiving records.
It's our determinations were, we said for both of these, sending back to the task force for review of the extensive redactions made to the provided records and possible willful violations. And then that was for the 049, And then for 083, we referred to the full task force for review of the extensive redactions made to the provided records.
Right, I see that. So that's why I'm confused, because Mr. Smith is saying that it's for records for 8.3, and Ms. Powers is saying for 8.3 it's for records and not for redactions. So that's why I'm a little confused here as to which one's which one are we doing here? Are we focusing on?
There's a lot of similar conversation.
Well, but I'm concerned about what the committee is sending back to us to ask for us to do, is to focus on the it looks like it's the focus on redactions.
So are we talking about 083?
Well, if I read the minutes correctly, they both just talk about redactions. They don't talk about production of records. It talks about to review extensive redactions. Vice Chair Josh Wolf.
I think the issue may be that there's both redactions and then the potentiality of documents that may or may not exist, which is the part that may have gotten a little bit less than clearly documented, because there isn't identified documents missing. There's the smoke of possible documents along with redactions.
I know, but we're being asked to review based upon compliance of an order of determination. The committee did due diligence to hear both cases out, and their recommendation is to bring it back to the task force to focus on extensive redactions, not on anything else.
Okay.
So that's what we're here for.
Sure.
Okay? Is there anybody has any other sense of things besides
I would
that?
just add that I think we've discussed the server who has access to it, who administers it, many hours, many months ago. It also overlaps with the Friends of the Library and the zoo and production of animal records and them abdicating responsibility to a third-party entity that does fundraising. Those facts are similar to other cases. I think we've discussed those issues at length. And I think that's been a huge issue in this, but it sounds like it was sent back. These particular two were sent back for redaction, scope of redaction, reason for redaction.
Okay.
Whatever.
Let me just ask the Member LaHood, since I think you're the only one here from the committee, was any of the discussion, was there any report from the museums that citing any codes or law that protects, that allows for those redactions?
I think the problem was that there was not a complete privilege log, so the redactions were not explained, and that was part of the problem.
Oh, is that true, Ms. Powers?
Bourne.
Oh, I'm sorry, Ms. Bourne.
Ms. Powers is not with us anymore. We provided Mr. Smith with extensive redaction logs when we submitted the redacted documents.
Right.
With citations, code citations for each one. I could show
Okay.
you a sample of it if you wanted to on the...
And the committee felt uncompelled by that?
At that meeting, it seemed that we were not satisfied by the presentation of documents and the conditions that they were presented in. This was 2 months ago. We were looking at specific documents with specific pieces redacted, and it was our opinion that the explanations were not sufficient for why those particular things were being redacted.
So even though they made a citation, there wasn't a reason? You didn't feel there wasn't a
Could I ask Mr.
substantial-
Smith to
Sure.
share? Mr. Smith, could you share some of the examples that were of particular concern to you?
The most, I'm struggling to answer this narrow question because in all candor, these issues have been addressed many times over many months, with referrals first to some administrative agency, then to the city attorney's office, and so on and so on. These issues have been dealt with and dealt with and dealt with. As to your specific question, and I'm sorry to say that, but it's the truth, and I'm probably one of the few people who was there throughout all this and knows it. But, for example, a smoking gun in the vernacular is that a curator said that wrote that funds from a particular fund that the museum has should not be used because they were, in my memory, inappropriate, and he objected. And then he set out, presumably, his objection, it was a he, over the next 2 or 3 paragraphs, all of which, the reasons, that is to say, that the curator felt it would be improper to use those funds, were blacked out. There can be no reason for that. No legally cognizable reason. I'm just giving you what strikes me as the clearest example, and I think that's why the committee was persuaded. And by the way, if I may just correct something I may have misstated, the commitment of the committee was not to combine or consolidate these 3 matters, but simply to hear them at the same hearing. That's all. So I straightened that bit out.
Okay, thank you.
So I would ask, what was the resolution on the issue of whether or not these documents in the hands of a contracted agency, COFAM, Silo 2, engaged by and entirely working for Silo 1, the fine arts museums at their expense, which fine art museums are a city department and so present themselves, are they not city documents, as I thought you had concluded?
Thank you.
Could I speak?
Yes, Ms. Bourne.
Pertaining to the concerns about redactions, Mr. Smith has been asked, I think, by both compliance and amendments and maybe also by the full committee, but I have to go task force, to come back to the museums and specify which ones he had concerns about.
Okay, but is he going to get the same answer that you already gave him, that you gave us with all the the privilege log? I mean, why now change your mind?
Oh, I'm not necessarily saying I've changed my mind, but that never went anywhere. He was advised by the committee to come to the museums with specific questions about specific redactions that he had concerns about.
Fine. That's fine. That's his prerogative to do or not to do. Mm-hmm. I think what the matter before us is still the matter of the compendium of redactions, mm-hmm. and whether the task force, the committee obviously felt that they were still not compliant with the order determination, and now it's here for us to determine how to move forward with that. I mean,
may I just answer?
Hold on a second. Hold on a second. The ordinance provides us with the limited enforcement or limited authority, but in this particular case, it does. If we do deem that the information is public, that we can compel the agency to produce it. And if we find that the reasons for the withholding are not sufficient. Member Yankee.
Perhaps I'm looking through the packet. I don't see the privilege log in here. Maybe it'd be helpful if we actually could view what some of these redactions are supposedly about.
May I just
Go
say
ahead.
that the point that Ms. Bourne just raised was addressed specifically and concretely, presumably it's in your minutes, by Frank Kanata, who informed the museum that it was not my burden to go through massive logs of alleged privilege redactions in this matter for, I suppose, the reasons that have just been elucidated by the committee. It's not a possible task if they mark everything or large quantities of material redacted. It's just not plausible.
I guess for me, it'd be helpful to know which specific, not line by line, but which specific redaction reasonings you're objecting to, Mr. Smith.
Well, I don't have all. It's a very voluminous amount of redactions when you add these three matters together, and even if you take two of them separately. So I'm not simply honestly prepared to do that, but what I would say generally is simply this. When they wished to find a way of blacking something out, as in the case of the disobedient curator, as I will for the moment term him, who gave a reason why funds should not be used from a particular fund at all, they gave, I'm sure, some reason or other for that, but it stretches the imagination beyond belief that there is such a valid legal reason. So I can't go through 100 or several hundred of these with you. I'm happy to tell you generally that the reasons, I accepted some of the reasons. Remember, first they said the number of documents was massive, and they asked me to drastically reduce, which I did. Then they withhold without telling me what they're withholding. Then they redact as to what they gave me, and they give standard language like, this is privileged because it has an address. Well, a lot of this is nonsense. When someone writes the city, as it's stated on your own city site and on, indeed, the city Board of Supervisors site, that is public. Another clear example is this. I'm doing this by memory because they're so stark and striking. They imported stuff, I finally found out, from Saudi Arabia for the exhibition they had. And they produced some of the agreements for the production of various items. And some of those listed someone either in or close to, I've forgotten, the Saudi royal family, and they were supposed to give the address, at least, from where this material came and the value. They excised, they redacted with black crayon or whatever, black marker, where it came from. It gave the name of the person, but utterly no address, which is completely wrong. There is no basis for that. And even though they had to disclose to the tax authorities and to the United States Customs Service the value of the goods and materials brought in, and they did so disclose, they redacted those. There can be absolutely no legal justification for that kind of activity. And that's what I'm faced with by way of example. I honestly, I understand that you wish me to be disciplined and to say as little as possible, and I'm seeking to do that. But after 18 months of going round and round and hitting the same question, which you've asked several times, be researched, and now asking about the redactions, which have been handled by the committee, and Mr. Kanat is addressing them directly. I mean, these many, not all, of these redactions are absurd. I told them I was perfectly content with redactions relating to security procedures and that sort of thing, things that are justifiable. But they have an absurd sense of what is redactable under the law. For example, addresses or anybody who deals with the city, they don't think that that is properly to be made known, which is wrong.
Mr. Smith, with your disobedient curator email, what was the reason given for the redaction?
I can't remember. I looked at it and it was completely implausible. I don't remember that particular one because we're dealing with hundreds of them.
But whole paragraphs of that email were redacted?
Yes, I threw them on the screen so the committee could see them. You know, I was there and used the projector with the kind help of your clerk, and they were on the screen, a huge blackout material. In fact, the deputy sheriff or somebody was there on another matter, and he was just looking at it in amazement. He should.
But that email isn't in our materials?
Well, yeah, it should be. It should be all blacked out because everything they're producing, I've made a point of making sure that the clerk is certified that everything I've been given has been given to you, and I've done that to make sure that the public has access to it. And your clerk has been kind enough to assure me that the museum has each time furnished you with a storage device that has everything that's been turned over. So it is indeed all part of your records.
Okay.
May I say just one other thing, and I'll stop, and that is I wish to call your attention to something I did file and which your clerk is kind enough to tell me appears in your agenda packet at item 3 at page 27. It's only 2 pages, I think, but it sums these matters, all 3 of these matters, up in terms of what has occurred and the tactics used, if I may say so, by the museum's respondents to do this. It sets it out in 2 pages. Again, it's item 3 in your packet, page 27.
Actually, 3 pages for us, but yeah.
Sorry. But the 2 of the pages are photographs of the museum marketing campaign. I didn't include those. They say your museum, whatever, DeYoung, your city, your museum.
The one that's titled "The Case Study of Freedom of Information."
Quote freedom, quote
Yes.
of information in San Francisco.
Yeah,
Yes,
okay.
That's it. Thank you.
All right. I just want to get some clarification with you, Mr. Smith. The privilege log goes on. It's pretty lengthy. Much of it are around redactions of email and phone numbers, things like that. Are those items? Are you disputing the redactions of those items?
Yes, unless they are very odd communications to the city. Anyone who communicates with the city does disclose his or her information. They are warned before communicating that is a consequence.
Okay, thank you. So, members, I'm wondering if the committee had parsed out the different reasons for redactions. So some are privacy and personnel, some are email, some are phone numbers, some
were information. I do remember the questioning why the location of the source of the donated artworks and the value of those pieces, why that was redacted. There did not seem to be a good reason for that. There shouldn't be privacy around the value of a piece of art that is loaned.
Because there is some precedent for redacting personal information. The question is whether it's personal or whether it's in the course of business. where they are a city contractor, and the discussion and the communications are regarding business of the city versus, an email discussing, what dinner is going to be for the evening.
Right, and it was not entirely clear.
Okay. So that's what we got to get down to here, okay, is the production of the redactions, to unredact information based upon for what reasons. Now, Ms. Bourne, in some of these that we're looking at on the screen, right at the top, one says like privacy email, California Constitution Article 1, Government Code 6250, and the Sunshine Ordinance 671G. Those are all the basic, kind of almost preambles of all three of the areas of public law, and basically just says that people have a right to privacy, okay? Private people, okay? The question here is now for all of these, everything that's on the privilege list, are all those private email communications? Or are they communications in the course of business between the city and those people? And I imagine those people work for COFAM or the foundation. Is that correct?
Mr. Smith, I'm sorry, you can't see what's on the screen right now, but there's a redaction log up of. Is it on?
Yes.
Okay, sir.
Yeah, it's working. We can hear. Can you increase the volume of her microphone, please? Thank you, Cheryl.
Can you hear me?
Yeah, there you go. Thank you.
The log that is up on the screen right now is, let me point it this way. It looks like it's mostly COFAM employees, with the exception of Max Holine, who was the director of the museums at the time. And so, I mean, I'd have to go back and look at every, as we all agree, this is a lot of emails. I would imagine that for most of these, it's COFAM business that's being discussed. And then there's another log here from our third document production that is all correspondence among city employees. If I can put this up. And, we have privacy personnel. It's mostly privacy personal phone number, privacy medical, privacy personal email, phone number. So that's probably somebody writing in from their personal email saying they can't make it to work that day, or they've...
Well, either way, the committee felt that the redactions that have not been produced as per our order of determination to compel you to do that hasn't been done. There hasn't been complied with. So I would say that, that they should be produced, that these emails be gone through. You took the time to go through each and every one of them to create a privilege log. I would say go back over them and see which ones are private and which ones are actual business, and if there is whatever happens, whatever is produced, and we'll deal with that. I mean, there's not much we don't have enough authority or enforcement power to be able to go much further than that, except to send it to another to a department or an officer that does, either the Attorney General, the DA, or the Ethics Commission. And we can put it in their laps and let them they will do far more investigation than we will, because they have more staff and they can do it in private and do a lot more discovery than we can here, because we do all of our discovery in public. So we're limited because of our ability, our authority, and the number of bodies to be able to do this, and resources.
May I speak? May I simply request that you do exactly that? You're not able to do this, you confess, acknowledge, and therefore, please send it to the district attorney or the attorney general or the ethics commission or whatever combination there is, and get this matter resolved after 18 months, because skipping the sort of bureaucratic twaddle for a moment, if I may be plain spoken and direct, they are saying, let's not gloss the point, they are saying that the only employee that they have to give the public records that are available only to their employees, and the only employees they have, from their point of view, are the city employees, who consist of the security guards, and that's about it. And everybody else who works for them works for this other agency, COFAM, which of course is their servant, and they pay them. And they don't have to provide any of those records. So when we're discussing this, please don't lose sight of this, the largest issue, the critical issue, that they are saying that they do not have to produce those records, even though they are on the same servers. I mean, remember the very first meeting or two, please, even though they're on the same servers, the same computers, and all the rest of it, and even though they hire this agency to do this work, they're saying we'll give you only the security guard stuff and or some other things perhaps that we absolutely have to. But it shows their intent beyond peradventure when they black out that reasoning for not being able to use money set forth by a curator, and when they black out the value of goods from Saudi Arabia, there is no legally cognizable, I say completely neutrally, reason for blacking out either of those two things, and everybody would know it. And that's what we're faced with. You are faced with an absolutely obdurate city department.
Okay, thank you. All right, members, what do you want to do?
I think if the redactions aren't, I mean, if I got a log like this and just said privacy personal email, I don't think that's in the spirit of what the Sunshine Ordinance kind of puts forward. You explain your redaction. I could get privacy personal phone number, but it's not explaining why it's being redacted. I just don't think they're complying in good faith with the order of determination that was issued prior about justifying the redactions.
Member LaHood?
I mean, is there an option to ask the respondent, will they go back through this and, reconsider the redactions and re-annotate? And is that something that we would find that would be an acceptable follow-up, or do we need to find willful violation for not complying with our order? Or could we give them another chance if they are willing to continue working in this situation?
It's up to you guys. I mean, if you debate it out, determine, figure out what we should do. I mean, if you want to, be done with it and send it off and have, you can send it to the Ethics Commission. They've got a pretty well-funded investigative department. You can send it there. Right now, I would not suggest sending it to the DA's office until the election is over and done with. We know who the DA actually is. I think it'll just sit around and languish at this point, at least through the end of the year, because we got the holiday season coming up. And I don't think we've ever sent anything to the AG's office, so I'm not sure what kind of response we'll get out of that. So I would say that the best bet is to send it to ethics. If the museums, want to stand on their current position.
I guess, can we ask?
You can, sure.
So
Go
I'd
for it.
like to ask, would the Fine Arts Museum, does the Fine Arts Museum present that this is all that is going to be delivered, or would you consider going back and reviewing the redactions and reviewing the privilege log and possibly providing more information based on Mr. Smith's additional request?
I would consider that. But I will say, and I mean, I would also note that the Commission and both Mr. Smith have acknowledged the large volume of this work, and I will just reiterate, there is no city paid employee that the museums has to do this work. I've now gone through 4 managers of board relations in 3 years. Melissa Powers left on October 11th. I've been advised for COFAM to try and find a public records clerk. I've been trying to do that since July, and I have not found a candidate to do that. I did get a $300,000 proposal from Robert Half to try to do that work for us, and we can't pay that money. So I would ask you to bear with the resources that we don't.
Well, let me just ask, why not just release the information? Why not?
Because they're not city agency records.
Aren't they records that
Well,
are?
I mean,
that are they're through your contractor. They're your contractor, right?
well, let me also be clear that the city does not pay the Corporation of the Fine Arts Museums.
Okay, so in a number of these redactions, you cite Section 5.101 of the Charter under charitable trusts. These are not contractors through your authority?
It's contracted through the MOU, but the city does not pay.
Who's the MOU between?
The MOU is among FAM, COFAM, and the foundation. But I'm just
That's
saying.
a contract.
Okay, but I'm just saying. At one point, it was said that the museums pay COFAM, but the Fine Arts Museums do not pay COFAM.
Doesn't matter.
Okay.
A contract is a contract.
Okay.
If I get a loan from the city, it's a contract. That's the actual description, the definition in city law.
I was just clarifying that there
so.
was an earlier comment made about FAM paying COFAM. And
Okay.
But
well,
I hear you.
Whatever the relationship is, an MOU is a contractual agreement of some
Yes.
kind. And we'll have to wait until we get our advice from our legal counsel for how that is. But in the meantime, if the Fine Arts Museum of San Francisco has possession and as custodian to these records, they are public. And obviously, you went to the trouble to create a privilege log of those. The reasons that were put in there were just based on privacy. It doesn't say that they were private emails. It just says privacy, personal email, privacy, personal phone number. But if that is, for instance, just looking at the list you have there, the 1, 2, 3, fourth one down, 2018 0110 13475 R Crump 1.12 D. It looks like De Young. It's short for De Young group schedule. Okay, that doesn't sound like a personal email about going to the carnival.
I suspect that was probably a schedule of volunteers who were working at the museums and all with their personal emails.
Okay, but it's still in the course of business. And if that's the case, then we should know what that is. I mean, personal email is not necessarily enough. If it's if we see it and it's redacted and it has, it's just the person who it's from, but that person is the executive director. I mean, this is in the course of the business of that they're providing to the city.
Okay, well, I mean, but talking about Rebecca Crump, I mean, she's working with a group of volunteers. She's not the director. So
I don't know that.
I know.
So that's.
But is it?
If it's redacted, then how are we supposed to know?
Is it the case that, I mean, are we going to need to go back and tell all of our volunteers that if they work with us, that their personal emails and their personal phone numbers and their personal addresses will be subject to disclosure?
Yeah. Yes,
We
and
probably
unless you're
will no longer have donors or volunteers.
Well, ma'am, this is not the first time that these kinds of issues have come up before us. We have them with all kinds of adjunct contracted organizations that work with the city, like the Friends of the Library. They are required to disclose their donors by law, and they don't. We've been over it, over and over again. If you think that will happen, that's not of our concern. Our concern is only about the production of the information based upon the law that's in front of us that we're charged with. That's it. We cannot go beyond that bound. If you feel that there's something wrong with that, then the law needs to be changed. But this part of the law is probably at the state level. That's floated down because the Sunshine Ordinance isn't independent of the state law. It is somewhat of an enhancement in certain areas, but for the most part, it's a repetition of the state law as apply, and it apply. The enhancement is that it applies to individuals as custodians rather as agencies as a custodian, which is of no consequence in this particular case. So, because we're asking the agency to make the production. So, in my sense, if you may have to do that, and you may have to get a legal opinion to determine what cannot be redacted, and then if we agree with that opinion, then so be it. If we don't agree with that opinion, then so be it. Then something else will happen.
Who would write that legal opinion?
Well, for the city agency, your legal representation is the city attorney, I imagine. Mm-hmm. Okay.
Yeah.
I'm just guessing here. I don't know if it is or not, based upon the concept of the charitable trust departments. But I imagine it is the city attorney, and if so, that they would be able to give you legal opinion as to what should or should not be redacted. Also, the Sunshine Ordinance has a provision for the public to engage the city attorney as the supervisor of records for a determination on this. And that also would end up with the same kind of process as what's going on here, but with one individual or a team at the city attorney's office. And you may get the same response from them as you're getting from us, the same determination. But they can't act as your legal counsel and then the supervisor records at the same time. There's a bifurcation there. So they may also not agree with the legal opinion of your legal counsel. I'm just guessing here. So I think for the purposes of this case before us, whether we can't take into account what the consequences could be about if the information is produced. That's for another person or another body to deal with. I think for us here is whether this information is public and if it should be produced. We've been through this for a very long time. It went through now compliance and amendments for monitoring. They have sent it back up to here saying that the redactions should be produced, should be the record should be unredacted, and that's where we're at. So I don't want to. We're spent an hour on this. I don't want to go much longer. If we can't come up with a motion or some way to move forward, then I'm going to ask that this be continued. And that
May I speak,
hold
or-
one moment, and then I'll have to review it to see what the best course of action will be. Member Yankee.
I mean, I have a suggestion that might be helpful, at least as we go forward. I mean, this is an extensive list. I understand it's, 3-some pages or whatever. And some of it, I mean, talks about privacy personnel. I mean, I'm not sure if that's a misspelling of personal, but personnel is a
Probably
totally
likely personnel.
different citation in a different part than it's talking about. Like, I'm looking at like the third one down that says P.S. Smithwick, and it says personnel. So I'm not sure, is this like an HR record or something, or personnel file?
Says supervisor, so it was probably discussing a personnel issue. Yeah.
Okay, but the code doesn't correspond to
doesn't
the
match,
personnel
okay.
parts of the codes. That seems very odd to me. But to my point is, maybe if we were to categorize the variety of withholdings that you're trying to use, instead of just listing them in this type of format, we could at least talk about each type and say, okay, our personal emails, should they or should they not be redacted, or what type of personnel. I think the other one had charitable trust listed as a reason. So I see a variety of reasons, and it's very difficult for us to go through all of these and go one by one. I think that at least helped me. We could at least have some movement forward if we had it in a more presentable format to us, because this just seems very overwhelming, and the wording varies from line to line that I think this is almost impossible for us to break down piece by piece.
Would you be kind enough to
Go
come
ahead.
out there to just let me know when is this okay? Yeah.
Yes, go ahead, Mr. Smith.
All right. I'll just say this and stop. But sort of this, I kind of think is my turn after all this time. I mean, the 18 months, not today. During the 18 months, I've written a 300-page book, which is now with New York Agency, 90,000 words. That's how much time has gone by. The museum, from my point of view, is moving not in the real legal universe as we know it, but in the universe that it wishes it were. There are no issues about a lot of this other than ones they're making up. I'm reading to you now from the Board of Supervisors' own website, which says, personal information, including names, phone numbers, addresses, and similar information that a member of the public elects to submit to the board and its committees may appear on the website or in public documents members of the public may inspect or copy. So, I mean, I'm sorry, but this is just a lot of nonsense. And then the representative who's not with him anymore, I guess, said, when asked, well, why is it taking so long? You can consult your record. She said the museums would move with, quote, reasonable speed. A startled member of the task force, hearing it, asked her how she got to that standard, reasonable speed, instead of the legal standard. She said, I'm not making this up. If she isn't, who is? Now, this is not only nonsense, forgive me, but it's unlawful. And concretely, if you don't want to be dealing with tons of redactions and so on, you told them unequivocally that docent material was producible. They had argued that it's not because they're volunteers. The chair was kind enough to ask, where are the volunteers housed? And their answer was, in the museum, in an office, and so on and so on. The questioning went on, and they were told to produce the stuff. I haven't gotten one single page of it, not one page. And I would therefore just submit to you, well, there's one other point I should raise, and I hesitate to do so, but I want to make you aware of it. It's incredible in my mind. The museums have retaliated against me. They have instructed their security guards to follow me and closely observe me while I am going through the exhibits at the museums. That's just incredible. Can you imagine being retaliated against or exercising a lawful right by asking you folks to help me get documents I should have anyway. And that's where we are in this. If you don't send it to the Ethics Commission, if you attempt to continue on the path you've been on for 18 months, I say with the greatest of respect and appreciation for the fact you're a pro bono body, you are essentially enabling non-production of these materials. You will allow them to string this out until I die or can't deal with the stuff anymore. You know, in the law, there is a standard in California. If you reach a certain age, then the proceedings are accelerated. But forgetting that, can you imagine yourself in a situation where you ask a public body for assistance against the city department, and the city department actually retaliates against you? Passing all that, please, folks, consider carefully sending this now to the Ethics Commission. You, I think, acknowledge in your hearts that you don't have the facilities, the staff to do this anymore on your own, and we can't go on for another year and a half. Thanks for your kind attention.
Members?
So a follow-up question. When at the museum, when I go, there's a clear, like, plexiglass box people put money into for donation. Where does that go?
I think it goes into an acquisitions fund, but I could get you that information.
But run by who?
By the foundation, the Fine Arts Foundation.
COFAM?
No, the Fine Arts Museums Foundation, FAM.
SF?
Foundation. There's 3 entities. Yeah.
Okay.
But I can get you that specific answer.
Okay.
All right, folks, what should we do?
I mean, we could send this to ethics, or would the museum be willing to? I understand privacy for personnel issues, which should be cited with the appropriate part of the code. Given the conversation here, would the museum be willing to remove the redactions on personal emails, personal phone numbers, and other requested information that has been redacted?
I really feel like I need counsel on that.
You don't feel like you could give an answer right now?
I don't feel like I have that authority. Yeah.
Can it continue to be asserted that COFAM is not something you're going to have to produce records related to COFAM?
I believe so.
Okay, then I would refer it to ethics. I'll move it to refer it to ethics.
I'll second.
Moved by Member Martin, second by Member LaHood. Any further discussion? Any public comment? Member LaHood.
Good afternoon.
It's on.
Good afternoon, task force members. I'm Richard Nee. In terms of where to send this, there is one other avenue for that, and that would be the Board of Supervisors. When I was on the task force from 2002 to 2014, we did send 1 or 2 matters to the Attorney General. The response there was, well, this is a local matter. We don't deal with local matters. Now, since that time, the Attorney General has changed. The office has changed hands. So if you want to try it again, you could. Maybe you get a different answer. As far as the DA, and I believe this would have been either Terrence Hallinan or Kamala Harris, the response was this would concern us only if we saw possibility that there was criminal activity here. We don't see that here, so we're not going to handle it. So that's pretty much where you are. Board of Soups, Ethics, DA, or AG.
Thank you. Any other public comment on the motion? Yeah.
Board of Supervisors, we did refer one or two things there and got absolutely no response. But again, you know, it's been 5 years since I was on the task force. Board of Supervisors has changed. Maybe it would be different this time.
Thank you. We ready to vote? No more public comment? We ready to vote?
So I would just say that one of the reasons behind it is it just seems at this point intractable, and I don't know what else can be done at this point.
Ready to vote. Okay, please call the roll.
Member Martin?
Aye.
Member Martin, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion is 10 to add those passes.
Okay, thank you. Please call the next item.
May I just say one thing before
No.
you?
Nope. Save it for the next item if it's similar.
Okay.
I'm sorry, Mr. Smith, I can't take obscure or erroneous comments in between items that are not actually in motion yet. So,
Okay, that's fine.
I appreciate that.
Okay, I do.
thank you. Okay, please call the next item.
Item number 4, file number 18049, complaint filed by Robert M. Smith against the Fine Arts Museums of San Francisco for violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
So it's the same call as the last one. Yes, Member Yankee.
Just quickly, should we do public comments since it's after 5?
Yeah, since we passed 5 o'clock. Yeah, why don't we hold off on just table this for a moment. Let's call for general public comment since
Would you like
we're
me to read
past the
item
5
5?
o'clock hour.
Read item 5.
Let's do that.
All right. Item 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Any public comment? Yes, no? Seeing no public comment? Okay, public comment is closed.
Want me to read item 4 again?
Sorry?
Would you like me to read item 4 again?
Yes, please read item 4 again.
Excuse me. Item number 4, file number 18049, complaint filed by Robert M. Smith against the Fine Arts Museums of San Francisco for violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner.
Okay, pretty much the same issue. Right, Mr. Smith? Pretty much the same issue?
Yes. I just wanted to point
Go
out
ahead.
to you, it's got nothing, it's just clerical. I think, send you something, but in the third order of determination, the one you just sent out yesterday or the day before, there's a drafting error in the last paragraph. I just wanted to point it out for your consideration. I think you're confusing, or somebody confused, COFAM, and I understand completely why, but COFAM, FAMP, Fine Arts Museums, and so on. So at the bottom, instead of saying, the Fine Arts Museum of San Francisco and the corporation and the foundation, it refers to the wrong entity. It refers to the foundation, as I recall, instead of the museum. It's only a drafting thing, and I just wanted to mention it to you.
Okay.
It's in
Is
the
in the
third
motion
order.
in the motion that was made? It says
No, it's in,
no?
in the order. Oh, sorry. No,
Go
it's in the order of determination in the last paragraph.
Right, that's what I'm looking at. Based on the testimony and evidence presented, the task force found that the Fine Arts Museums violated Administrative Code Section 6721E. It should be all three, you're saying?
No, it's sorry. Let me pull it up. I I had quoted it and then I shut it down. Give me just a second. I apologize for this. Gosh. It's an obvious error. I think. Just 1 second. Bear with me just 1 second.
Well, while you're looking at it, it's
Yeah.
not necessarily
Oh,
substantive.
drafting error. Here it is.
Yeah.
It says the order reads, the SOTF requested that the SOTF city attorney provide advice regarding the relationship between the corporation and foundation of the Fine Arts Museum. I think you mean between, or I believe you mean, between the Fine Arts Museum of San Francisco, FAMSF, and the corporation of the Fine Arts Museum, COFAM, and the Fine Arts Museum Foundation, FAMF. But if you say the corporation and foundation, then you have swept out city department, which is the Fine Arts Museum of San Francisco, FAMSF. That's all I'm trying to point out.
Okay. All right. Thank you. All right. Members? I mean, here, again, the Compliance and Amendments Committee has referred this back to us regarding same issue, right?
Very, essentially the same issue.
Issue. Okay. Is there anything that is specific that we need to review with regards to this? Otherwise, how do you want to dispense with this?
I mean, I think other than, we should probably hear from the museum again.
Okay. Ms. Bourne?
I think that what you're considering is whether you would just take the same action in the two matters. Is that? I think that would be the simplest course. I mean, to me, and I think to Mr. Smith, these are largely the same issues.
Member Martin?
Do you want me to respond? Or?
No, Member Martin
Okay.
wishes to speak.
No, I was just going to say thanks for the input, and if anything else comes up, let us know. Mr. Smith, do you have anything to add?
Just one thing. I don't know if this is within your purview. I honestly have no idea. But is there anything that you can say or urge that might prompt the museum representative to stop the museums from retaliating in the fashion they have? Is that possible for you to ask?
I don't know. I mean, I think Chair Wolf might. I don't think so.
We don't have the authority to determine what happens outside of this hearing room per se, except that the Sunshine Ordinance should be complied with. As far as what the actions are or are not of a department in the course of that compliance is not within our jurisdiction. Our jurisdiction is based upon the actual compliance. So if there is some, if somebody's preventing you, creating like a physical barrier from you being able to see documents, that's one thing. As far as monitoring people's movements, that's not within our jurisdiction, and I'll stand to be corrected. Our legal counsel is sitting here with us. Maybe help us with that, but I don't believe we've been through this several times before in various other cases. And it's one thing to block somebody's access into this room, which we've had to deal with at times. We've had some cases where in years back where people were prevented from seeing actual documents for various reasons, and so that's a different story. So I'm not sure that we have any authority or ability to help in this situation where, for whatever reason, a department or agency is called law enforcement or some sort of security to monitor the movements of a member of the public.
Well, can I only say for the benefit of your city attorney that in forming his opinion, which I assume he or she is about to give you, that if somebody, a citizen, comes before you and the city department involved in the complaint before you then retaliates against that petitioner to you, the city body, then that chills the whole purpose of your existence in the sense that other people will not come forward and not use your services if they are free to do that.
I completely understand that, and that's something that if we see that as a pattern, we would definitely report that to the Board of Supervisors. But that in and of itself for the people involved is not, I don't believe is a matter for this task force. It's a matter for the law enforcement to deal with.
Or I suppose now the Ethics Commission.
Or the Ethics Commission, yes. The Ethics Commission has, I don't know if it's the same kind of enforcement, but I think at some point they could create some sort of order for that to stop. Absolutely.
And do you not finally just think that you don't have the ability to just say to Ms. Bourne, can you stop this activity?
We can say it, and we've said it to other agencies, including law enforcement, when it's not clear why they are monitoring certain people. We're never quite sure that how much gravity our requests have. So I will ask Ms. Bourne if there's some compelling reason. We ask that if members of the public are requesting to see records in general at your office, they have a right to do that under state law. Actually, yes. They have a right to do that. So, and without intimidation.
Yes.
Okay.
I understand and I agree.
Okay. Thank you. All right, members.
Yeah,
what should we do?
I would move and make the same motion I did on the previous one to refer the matter to the Ethics Commission at this point.
Moved by Member Martin. Is there a
I'll
second?
go ahead and second again.
Second by Member LaHood. Any public comment? Seeing no public comment, please call roll.
Member Martin?
Aye.
Member Martin, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye.
Motion
Motion to refer to the ethics passes.
great. Thank you. Okay, please call next item.
Just to kind of.
Thank you,
Can I get
Mr.
off
Smith.
this line?
Yes.
Thank you. Thank you.
Okay, next item, please.
I just want to reiterate, item 6 has been withdrawn,
Oh,
as I
right.
said at the beginning of the hearing. I can read item 7 if both parties are here.
Yep.
Item 7, file number 19052, complaint filed by Alex Koskinen against the Department of Public Health for allegedly violating Administrative Code, Section 6725, by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, Mr. Koskinen, did I pronounce that correctly? Yes. Thank you. You have 5 minutes.
Hang on.
Bent.
Hang on.
Hello, members
Hang
of the.
1 minute before you start. Member LaHood.
This was just about finding jurisdiction.
Okay, thank you. Go ahead, please start the clock.
Hello, members of the task force. At the previous meeting, I discussed why I was here. Way back in March of 2019, I submitted 2 information requests, one immediate and one not immediate. The department did not respond to the immediate disclosure request and did not notify me. They notified me late that they would like an extension. They eventually did respond 2.5 months later to that first one, so that one is resolved, I believe, but it's still an issue of, is there any accountability for the lack of timeliness? The second information request had 4 parts to it. DPH has responded, I believe, adequately to the first 2. The second 2, they have said that they have not quite, they provided a response, but their response, it wasn't that we don't have records. Their response simply stated, we don't have a report that's responsive to your request. I know that they have documents, or at least at one point had documents, or should have had documents. So if they are, I asked them for clarification. Are you saying that you do not have now and never had these records, and they have not responded? What I was asking for was employment application information. So when people applied for positions at DPH, how their experience was verified. I was asking how their hours of experience were checked. So if a job posting had some sort of requirement, say 2 years of supervising people, then how did DPH verify that information? What records did they have? Timesheet data, et cetera. And they must have had that when they determined whether or not employees were eligible to go on eligibility lists for positions. And so those records must have existed at some point. But from speaking in person to the Veronica Vienne from DPH, who seemed to be the their task force liaison person, she said verbally that that information was deleted and only kept for people who eventually got positions. So I asked for a copy of DPH's record retention policy. They haven't sent that either. So at this point, I'm either looking for the documents that I originally requested, or a confirmation from public health that they deleted them or they never existed in the first place. And I'd just like to point out that it's been around 5 months at this point, and it seems well beyond the timelines, and DPH doesn't have a real sense of urgency, and they just have not been very responsive or cooperative. So that's it for now.
Okay, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the complainant, the petitioner? Seeing none, Department of Public Health. Respondent.
Good evening. Linda Acosta, Public Health. I'm new to this particular case. Veronica Vienne is on vacation, so I'm handling this for her. I understand that we have given many documents. I do have a copy of our records retention policy here with me tonight, which I'm happy to provide. I also understand that the documents that we are obligated to provide under Sunshine are for employee records, not necessarily applicant records. And so that's what our city attorney instructed us, that we were required to provide any records that were employee records, but not necessarily applicant records. I also have from my HR department a calculation of how many hours it would take them to come up with what it is that Mr. Koskinen is asking for. So I can go into that now. Yes?
You have 5 minutes.
You have 5 minutes for
why not?
however you want
No
to
time
produce.
like the present. Let's get through it. Okay, so they have calculated, and from what I understand, Mr. Koskinen wants, out of all applications for the last 5 years, he wants to know which of those were from city employees moving into, applying for another job. So our HR department has calculated that it would take about 7 to 10 minutes per application for approximately 25,000 eligible people. It would take them 5 to 6 minutes to redact each one. It would take 10 minutes to review each application, 15 minutes. 15 minutes for redaction plus review, and a total of 64,000 hours, which would be 8 months of an analyst's time. So they're saying that that is a burden on the department, given all that they have to do.
Okay, any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members. So I have some questions. Mr. Koskinen, sorry. Was your request for any and all records, or was it for a specific period of time, particular position?
It was any and all, just to evaluate the process and whether or not it was being done consistently. So I know that there is a large volume of records. I'd be willing to work with the department in maybe narrowing the scope of that. But so far they have provided a single record, and it was not quite what I asked for. It was in the format that I asked for, but the wrong time period. So they
What
definitely,
time period were you asking for?
before employees had, when they were applying to positions,
Oh, okay.
what was their experience. They gave me one single employee who had already gotten a position,
Okay.
and for the subsequent time period, their hours and
So
labor data.
it sounds like you're asking for two different things. Let me see if I get it right. So you're asking, one, what is the kind of general criteria? And two, how many?
So I'd just like to know how they verified the documents that they used to verify people's time to meet application criteria. So if a job posting said this position requires 3 years of experience doing this type of work, then how did they verify that
Okay.
criteria had been met?
Want to say something? Okay. All right, thank you.
Well, actually, I do have a question.
ahead.
So
Go
what
ahead,
kind of
Jessica.
specific information would you be looking for? Just the process that they use to verify that, or?
Yes, where they got the hours, what timesheet hours they were including, were they including overtime?
Why do you think that there would be timesheets?
For all city employees have timesheets.
No, but I mean, if somebody, let's say, was applying for a job externally for a position?
So I had limited my request to only city employees who were
Okay.
applying for positions, so I know that the data would exist for all of those
Okay,
applicants.
is there, why do you think that the HR department would have pulled timesheets? Do you know that is the written practice to pull the timesheets of their
No, if
previous
they're-
positions?
Sorry, if there were other sources of data that they were using to verify time, then I would have liked to know what those are and see an
So,
example.
for example,
of
maybe
some of those.
calling the supervisor that was listed for that person and verifying the work that was done, or just because in my experience, I've never heard of anyone pulling timesheets.
So
for that,
if that was their process and they were not actually verifying that the employees had and were just asking somebody, hey, had this person worked this time, then that's a legitimate, valid answer. If they can give that, then
That's their practice.
exactly,
Okay.
yeah.
But you didn't get that information?
No.
Okay.
And I suspect that can't possibly be the case. I mean, they would have to verify, otherwise.
Not
I
necessarily.
would suspect.
That's not
Did-
necessarily. They could verify using other means. They wouldn't have to use a timesheet.
Yeah. But I guess to the crux of the matter, did the department provide you with any information as to what the criteria with regards to any applicant that of a city employee applying for a job in their department?
No, they haven't given me any sort of procedure that they use to verify that applicants have met
Okay.
criteria.
Great. So let me ask the Department of Health a question. Ms. Costa, do you have a set of criteria for
I don't
applicants?
personally have a set of criteria.
But does the department do?
I understand that they do.
Okay.
Civil service rules, and I don't understand exactly what all of those are, but
Okay.
I know they're very tightly kept and followed very closely.
Are you able to provide Mr. Kostanen this information?
Well, I'll tell you what we did provide, and I'm not sure why that didn't help, but there was actually a timesheet in Excel that we did provide to him. I can put that up. All for the position that Mr. Koskinen was looking at, which was a 0931 position. And this is an employee number, 045714, and these are all their hours.
So let me just ask you, go back to my question. You've answered his question about a timesheet. My question is the set of criteria. Is there a particular standard practice within your department for reviewing applicants and their prior experience? And what is that?
I'm sure there is.
Okay, can that be provided to Mr. Kostanen? Because that's that he's asking for two things. One is, what's the criteria? How do you go about these things in general for all employees? And you mentioned civil service. Okay, so that's pretty standard. There's a lot of very stringent rules around that based on collective bargaining and all that kind of stuff. But then there's the other part, which is the specificity. You want some examples.
Sure.
Okay, so let's deal with one issue at a time. All right, are you able to provide him with the first part?
I would need to go back to HR to get, some content around what it is exactly that they do. I mean, they've said, they adhere to very strict policies, yada, yada, yada,
Okay.
but not exactly what those are. So
Okay.
I would be willing to go back to them and ask
And-
for that.
Yeah, absolutely.
And by that, Chair Wolf, it could be something like, and correct me if I'm wrong, like if you are hiring someone as an analyst in HR to look through applications for qualifications, how would they be instructed to complete that task?
Exactly.
So I would be willing to go back and ask that question.
Okay, very
Yeah.
good. And the second part is the records that he was requesting. Now, I hear it, you're saying it's voluminous. I think Mr. Kostanen is willing to try to narrow it down. I think if he can determine what would be an adequate representation or example for what he's looking at. I mean, you're providing us with some information here publicly. I imagine you could provide something similar. Let me ask Mr. Kostanen, is this something that would help the kind of information you were seeking?
So this in particular.
Can you please come up to the microphone?
So this was the example that I mentioned. This is the timesheet data of the person after they had gotten a position. This is not the time that was used to determine whether or
Got it.
not they were eligible for the
Okay.
position.
Okay, great.
So this is the format that I would like, if available.
Right.
But-
So the question is we don't know what their process is, and we don't know if as part of either the Civil Service Code or part of their own internal methods or their approach to doing interviews and reviewing, that they use that process of looking at timesheets. That, frankly, in my experience, might be privileged information that cannot be shared.
It likely doesn't even occur.
Yeah, right.
I've been through civil service hiring. You do not look at first of all, this timesheet does not give any explanation as to what the person is doing. It says that they are holiday pay, it says regular hours worked, it doesn't say what the tasks are. So you wouldn't use a document that looked like this in order to determine if this person has the skills required for a position. This does not
Okay.
give you that.
Fair.
Yeah, and in my experience, you would not pull information like that to determine if the person meets the qualifications either.
Right. I think what you're looking to go after is just what is their criteria, and if they don't do something like this, then it answers a different question for you. Then.
Sure, but what this would tell you was that this person was in fact working in this job for this amount of time, and I believe that is at a high level what is verified.
It's not up
typically.
to us
Sure,
to
I
determine that.
understand.
So it's for us. It's about whether information you requested, whether you got it or not, and if it's being withheld, what is the reason for it being withheld? Okay.
Sure.
If their process is, if the question that you're asking the department is, what is your criteria for determining, experience, when you say, must have a minimum 3 years experience in social work, how do you determine that? Okay. That may or may not include a review from the previous employer of timesheets or other information. But frankly, I don't know in any business or even government whether those are personnel records. They're not necessarily disclosable. These are here because they're not disclosing the exact person. They're just disclosing the class number. That first column is the kind of the classification number.
The first one is the employee ID, so it does identify
employee
the,
ID. Okay.
the person.
Yeah.
Classification is 0931.
Oh, okay. So anyway, be it as it may, I'm not, having been in business for a while, I would never reveal any personnel files. If it's, in general, I think that you have to look at their criteria. I'm not going to presume what people should or should not do. It's best to look for get the criteria. They may just hand you the Civil Service Code.
If they were to provide this in redact names, that would be fine. I'm just looking for if documents exist. Do they have documents that they use to verify people's time? If they do, I would like to see those.
And in your testimony, your opening testimony, you said that they reported to you that your request for those records were unresponsive, that they didn't have any records that were responsive to your request.
So if they can they haven't confirmed that, their response said only they don't have a report that can tell them that. They did not say we do not have records. So if they tell me we don't have records, then I would accept that.
I don't
Can
know.
you point to where in the packet they said that to you?
I had sent information to Miss Ledger.
Yeah. Whatever you said there.
So all of that.
Was that done via email, on the phone? How did
Yes,
they
via email.
Is that in? Did you submit that for the record?
I tried to. I asked Miss Ledger what the process was for getting all of this information in front of you guys.
Okay. Do you remember which document that is? Which email? What the date was on that, or what it said? Do you know what do you know what page it is in our packet?
I don't believe I have your packet in front of me. Would it be
Okay.
over there? Or Miss Ledger, do you know if what I sent ended up in there?
It looks like the information you sent information, but we just need you to be able to show us with specificity, what you received and what's inadequate.
So really, this is the
found
single response that I received. It's this.
Page 693.
But was there an email that accompanied this document that said anything on it?
There was a written document. I can put it up on the monitor. I have it here.
Great.
Yeah, members, if you look at page 693, that's the disclosure request.
Thank you.
I believe this is the relevant paragraph where they say a report doesn't exist, but they don't say no records exist.
Did you request a report?
No, I requested the documents, the information itself.
So
I take that to read they'd have to compile the information in a numerical or data form by
do you
going
have-
through the submitted applications.
Does anybody have the page number that this document on the screen is? I just don't want to look at something that's not in the packet. I'm trying to figure it out, and I can't find it, but.
hold on a second. Is that on page?
Or can you pull the
is-
document down so we can see the top, and then that can maybe help us find, okay, a report or list, or,
Yes.
This may be neither here nor there, but if you look at page 685, which is the complaint filed with the task force, it's limited to, as I read it, and as we wrote our memo, correspondence regarding Alex Koskowskin and PBT, and et cetera, including all emails and documents written by DPH or any other city staff, including HRD staff, by 10 a.m. Tuesday, 5/14/2019.
and you point that out to show.
That what's on page 693 seems a much broader request than what was filed with the task force.
I
Yeah,
see.
there, actually, the one on 693 is an extension of the original request made on May, was it on, wait, 14, 693, it was on April 15th. That was his original request, April 15th.
Can I
Yes,
place
go ahead.
another record here?
Yeah.
Here's a email that I sent on October 29th asking.
Can you move it to the right just a little bit? Yeah, a little more. Yeah, there you go.
Here's an email I sent with attached documents that I tried to enter into the record. This was the second email that I had sent, and I had not gotten a response to either, so I'm not sure what information you do or don't have.
I'm just saying the document that you have on the screen, that's right here where it says a report, or if you remove your phone, that document. I'm just trying to find out where it is in the packet, and I just don't see it in the packet, so. But what I'm trying to specifically find out is where in the packet, I wasn't able to find specifically what they gave you that you're referring to as a report or list.
Mr. Koskinen, I believe the deadline to submit information was the Tuesday before 5 o'clock, this past Tuesday. I
That's
posted
why
the
it's not
agenda on
there.
Friday, and I need things timely.
So I'm looking on page, is there a, Mr. Costin, just to help us out, because I think that what we're looking for is the original request.
Sure, I have that.
And
So I'm looking at page 732. There is on Monday, April 15th. Hi, Juliet, is that the one? No, jurisdiction's already been found.
Here up on the screen is the original request. And I had requested, as I was showing on my phone on August 20th, asked for this information to be entered.
Yeah, but here, this is on page 693. It says pursuant to your ordinance, please provide the following information. But then it says, lastly, please send the information I requested in my 415 email. Is that what this is, 1 through 4? Was that in your 415?
So this was the original information request, the non-immediate disclosure request. So this is items
Okay.
1 through 4.
All right, so that's, okay, so that's what you were looking for. All right.
And then, just to be more specific, did you receive web links to all the job announcements?
I did.
Okay. And then for number 2, did you get web links to all eligibility lists for the aforementioned
I did.
announcements? Okay, good. So 3, did you get a list of all the city employees whose experience was verified by DPH for the aforementioned
No,
announcements?
3
Yeah.
and 4 I did not get. I got
Okay.
that single record.
Yeah, and I actually, honestly, I'm surprised that that single record was even provided with the specific employee ID number.
And based on what the city said, it sounds like once someone is hired, they don't keep
All of the other
all
applicants.
of the other applicants.
So I guess what they need to have is what is the written policy, and at least provide him with what their written policy
Right.
is.
I think that's a,
And then number 4, of just to finish going through the 3, if I may. Number 4 assumes that the timesheet data is even looked at, and in my experience, it's not looked at. So I understand why they didn't provide something for number 4, but they would need to specifically say that to him, that we do not use eMERGE timesheet data in order to verify in a person's experience used for minimum qualifications.
I think what we're saying is that you need to start with their process. If you think that their process is flawed, that's a different story, okay? Based upon what you think your opinion is about how this is determined. That's not for us. But I think you being provided the process itself would help at least start your own investigation.
Sure, and just if documents exist, if they did look at timesheet, or if they looked at if they have some other record that they used, if they could provide that, or say that they just confirm that they don't have it, because I didn't read.
Their process would tell you how they do
Right.
it.
And the first step would be getting the process. This assumes as if this is part of the process, which at this point we do not know.
Sure, but I'm asking for the records, so if the records exist and they're public, then isn't that part of it as well?
Well, we're not necessarily just entitled to an employee's ID number. If they don't have this information, why would they have this information if they're not using it in order to go through the process?
Let's
right?
presuppose for a second that he just independently asked for that,
Yeah.
the timesheets data. The question would be, what would the employer's response be then? Okay, and that would be the answer to that is, so you wanted you wanted the timesheet data for the aforementioned employees. So the aforementioned employees are
All the city employees who applied for DPH positions.
right, and so
Yeah. So they may not have it, but if they do, I'd like to see it.
right, and so that's, I think their response. One response we've heard from them is that it would be a voluminous task.
And I would be happy to work with them to winnow that down and maybe get a
I don't
subset.
know that you'd be able to, because you'd be seeing personnel records that are not privy for public consumption.
So from what I understand, employee time data is hours specifically is public information. I mean, it's published in the newspaper every year, the 100 highest paid employees in the city, all that stuff.
Okay.
So, and it's published in the state website. I believe you can look up any employee and their compensation and
But
all
not their
that.
timesheets and
Right.
when they took sick leave and things like that.
So if they could limit it to working hours, then that would be fine. Or if they could redact employee IDs, that would also be fine.
But here you're asking, what you're talking about, what's published, are for current employees, right?
And
You're asking for timesheets or hours worked by applicants.
But city employee applicants, so that information would be public. So if I were to apply for a job and use my past city experience as
Okay.
to say that qualifies.
Okay.
My concern here, though, is let's say that there were three city employees who applied for a job, and he gets their list of names through number 3. Then he also gets the timesheets for the 3. Then even if the names aren't on there, he knows that it's one of these 3 people. So it's not really, their privacy is not being protected if you're trying to get.
But that could be redacted.
Their name would be redacted, but there's only 3 people.
The pool is too small.
The pool is too small. So anyway, I think that there's a presumption anyway from number 4 as if they even look at the timesheet.
Well, the
data.
employee ID could be redacted too. The classification is public because the whole strata within civil service is public, but the employee ID and the name could be redacted. He's not really interested in that. He's just looking for applicants and their amount of hours. For me, there are 2 things. One, it's hard to make decisions around people's intent on why they request things. Okay, they can request one thing with regards to this is what I want to know what the process is. That's one request. The next request may seem like one leads to another, but they're independent. It's not for us to determine intent.
And the point here is to see if they followed the process, but you need to figure out what the process is first.
Member LaHood.
May I ask a question of Ms. Acosta? So just because I think we're talking about details that might not even be relevant. So when there are job applicants and then someone is hired, is the list of who applied for the job and was not hired, is that maintained?
No.
Okay. If that list is not maintained, then there is not going to be a list of employees who applied for jobs whose experience was verified at all. So that makes 3 and 4 are impossible to find.
Well, let's verify that. Is that the
Is that
response
correct?
that you gave the petitioner?
So what HR is saying is that they would have to look at each one of these applications, determine, these 25,000 applications, determine if that was a city employee, right? And so that goes into their calculation of how many hours it would take.
Okay.
No, I guess my question is, if a person, we have 5 people applying for a job, A, B, C, D, E. You hire person B. Do you keep records on the fact that A, C, D, and E applied for that job and were not hired?
From what I understand, we keep only the records of the person who is hired.
Okay. So the people who were not hired, you're not keeping the application. So you're not keeping a record of the fact that, person A has applied for 10 additional jobs with the city and never was hired for any of those additional jobs.
Correct.
But of the person who was hired, you may have that information.
Yes. But in order to find that, again, you would have to go through those 25,000.
I understand.
Yes.
I have another question after that for Mr. Kostanen, but after Member Yankee.
Do you use like an eligibility list, like a rule of 5, rule of 10, or whatever?
Oh, yes.
So I would
Civil
imagine
serv-
while that eligibility list is active, you would probably have that information for everyone on the eligibility list. So probably 5, 10.
Again, I'm not in
Pass,
HR, but
right.
I imagine, they have the rule of the list, they have those names.
Oh, okay. So in civil service, oftentimes what happens is you get a large pool of candidates. Let's say there's 20 of them that apply. They'll often use a quantitative way to rank them. And let's say you use the rule of 5. So the people with the top 5 highest scores are then forwarded to the hiring manager in the department to choose off that list. The other people would be ineligible for that unless, let's say, person number 2 is selected. You could pick anyone at the top, let's say 5, the way this works. Once that person gets the position, there's a new rule of 5 because it bounces down and you have, number 6 becomes number 5 and so forth and so on. And that would typically, those eligibility lists are maintained for a period of 1 year. I'm not sure San Francisco's civil service rules, but in my experience, there's a period of time that those are eligible, that list until it expires and you go through the recruitment process all over again. Does that answer your question? Okay. But secondly, I'm also looking at the 6724, and it kind of talks about some of the disclosable items related to this. And it talks about which ones should be disclosed, and I'm looking at 6724C, where it talks about personnel information. C1 talks about job pool characteristics and employment and education histories. And it just says of all successful job applicants. So I think that might be to the point that, ones that are not successful are probably not included. And then the one thing it does talk about, it says years of employment in the private or public sector. But I think to Member Tesfai's point, that's not timesheets. I mean, I could just say, yes, that person had 3 years. I think that would qualify and meet the requirements under that.
Right, and I think for the purposes of this, that if the criteria was to call or speak to a previous employer somewhere else in the city, if, that a response of how many years that they worked there could be verified.
Right, and oftentimes, there's also oftentimes systems that will show, how many years you have in a system, for example, if you're in the retirement system or whatever, which has nothing to do with timesheets. You wouldn't even need a timesheet to do that type of verification.
Right. So, Mr. Koskinen, let me ask you a question if you could come up, please. Okay. This is not going to necessarily, I'm not trying to dive into your intent for this purpose of this information, but possibly see if we can come to some agreement to help you get the information you're looking for. Is there a particular time frame that you would be satisfied with, considering if you're asking for all employees or all applicants since the beginning of time is not actually feasible, and the ordinance actually, doesn't require that to happen, okay? But if you can narrow it down to like a particular period of time, you want it over the course since January 1st of 2019, or over the past year, or some previous year period for some particular reason. If you can narrow it down a little bit, I think that might help you get the information that you're looking for.
Sure.
Possibly.
If it exists, I'd like public health to say one way or another, do we have anything or not? I think that's the first place to start.
Well, I think from their admission and their testimony is that once a person is hired, all those applicants are then deleted.
So going back to what Mr. Yankee was saying, sorry if I assumed that you had some more knowledge of the city's hiring processes. There are eligibility lists for each civil service non-exempt position that goes up. Mm-hmm. Those are maintained for many years, if not forever. So there is a record of everybody who was verified, whose time was verified for each position, who was verified as eligible. And what I'm looking for is what information, if any, does DPH have that confirms that allowed everybody to be on this list? So
okay,
on each list that they have. And I could narrow that down to certain job classes or time periods. But again, it starts with DPH just saying we have something, and so far they have not provided. I don't think their response is one way or another, we have or we don't have. They just say we don't have a report, which doesn't answer, do you have records?
All right, thank you. Any other questions for discovery on this? Should we move to rebuttals? And then we can kind of get to the meat of it. Okay, great. So, Ms. Costa, you have, we're going to have rebuttals. You have 3 minutes to rebut any information or anything about this case.
So I'm happy that we would at least try to narrow this down, but I'm still not clear on what it is that Mr. Koskinen would like. I mean, we don't have records of the applicants, so, maybe HR could furnish for position 0931 successful candidates and how many hours they were found to, experience in what areas. I'm not sure exactly what he wants, and I think we need to really clarify that if we're going to go outside of what we were requested to do.
It's your 3 minutes.
Oh, well, I thought you had a question.
I thought I did too, but
You can't ask in the middle of rebuttal.
I know. So sorry
Okay.
about that.
If that concludes your rebuttal, Mr. Koskinen, you have the last word. 3 minutes, please.
I think what I'm asking for is pretty simple. Just do records exist, yes or no, for a clear answer on that. If they do, can I have them? Am I allowed to have them? What redaction or filtering method could be done to limit this information? DPH has something. Well, they must have something when people are applying for jobs. Has the verification information ever existed at any point and they threw it out and destroyed it? That seems to be what they're saying, but I'd like them to confirm that once a hiring process is over, we take all unsuccessful applicant information and delete it. And then I'd like to review their records retention policy, and is that appropriate? That's outside of the scope of this, but it's basically, do they have records and can they provide them? And that is the question that I feel like I have not gotten an answer to yet. So I'm happy to work with them. I've been in contact for over 5 months now. I feel like there has not been a great sense of urgency for the department. If you guys could set some sort of time limit, if it's in your power to set some time limit for providing maybe some small number of records, 10 records or something, or a reasonable amount per time period that they should be able to provide, then I think that would help me get to what I'm looking for. So thank you very much for your time.
Thank you. Okay. Member LaHood?
It seems like 3 things are needed. We would like to ask the department to provide information about their hiring and experience verification process. We'd like to ask them to what their records retention policy is regarding job applications, and then for both parties to work together to narrow the scope of their request so that it could be responsive and also completed in a timely manner.
Okay. Anybody else? All right, so I have one more. I mean, thank you, Member Yankee, for pointing out 6724. That's very applicable to this. And I think what might be helpful with regards to the exact request is the only application that is in existence that was part of the original submission, which is the successful one. Okay, and under the ordinance, that information must be made public, sans any applicable redactions. So I think that that's something that could be provided, that we can also see if it's possible to be provided. So I'll ask Mr. Koskinen if you come forward. Would that be helpful if the only information that's available, according to the testimony, whatever previous job application process or application period was open, and there were a number of applications that were submitted, and then after the person is hired, all those other applications are discarded, and the only thing that's left is the successful, person who got hired, their job application. Would that be enough information? Some of those, would that be helpful?
Sure.
you?
If that's the policy and if that's what's happening, then yes, I would like the records for the successful applicants.
I'm saying, it's one thing what their policy is. The second thing is what you're here before us. We have a body of law that we can only follow, okay, that's within our jurisdiction. So we've already found that the information is public, but it's only specific. It's specific only to successful job applicants.
And can you compel them to provide that in writing, that they discarded information if that is indeed what they are doing?
Well, it's on the record. I mean, it's
Okay.
it's on the record. You can't get much better than that. This is an official hearing.
Well, if there's a written policy, maybe that could be.
Yeah, I mean,
provided.
the retention policy would specify that, and then at that point it could be you can review the retention policy against what the retention policy rules are in the city. We have our there are retention rules within the ordinance and within state law, but in many cases they're left up to the determination of an agency or a department. So,
Sure.
Hold on, Member Yankee.
Yeah, I mean, even if they did have applications of unsuccessful job applicants, I'm not even sure that those would be disclosable because there specifically talks about successful job applicants.
Right.
So regardless of whether or not they have them or not, I don't see where they would be disclosable.
It's a good point. It's an implication.
Yeah.
Yeah, I get it. That's a fair point. All right, so how about we try that? So, Ms. Costa, I'm wondering if maybe we could meet in the middle here somehow. Is there some period of time, Mr. Kostanen, that would be satisfactory for you in order to get some documents fairly quickly if they're in agreement?
Does 2 weeks sound reasonable?
No,
3
I'm
weeks,
saying period of time of applications.
Can
And
I
don't think they're going to agree to every single
Sure.
job applicant.
I think limiting it to job classes would be more in line with what I'm looking for.
But from the beginning of time?
No, for the last 5 years was what I had asked for.
Oh, okay.
For which job classification?
So I could come up with a list, maybe everything MEA.
It's like it's going to be a lot, but I'm just, that's fine.
I mean, let's start there, okay? And why don't let's see if DPH is willing to meet with you to come to some reasonable period of time, and then we'll, if it doesn't work out, then you can let us know, and I'll be happy to set up a hearing before our Compliance and Amendments Committee so the details can be heard.
Sure, thank you.
Okay.
And would it be reasonable to specify a time period in which this meeting would take place?
Yeah, sure. But let me have Ms. Costa step up, and we can kind of get an idea from her how quickly we can get this expedited.
So I would want to be clear on how many.
Right. So we're going to say
positions.
what I'm alluding to here.
Mm-hmm.
Is as a solution is to for you two to meet and for you to discuss and negotiate what would be a fair period of time within the labor resources you have to do it, and what would satisfy whatever he's asking for this information for, whether it would be sufficient. That would be the first thing. Second
Okay.
thing is to provide him with your rules of the road and what your retention policy is. And
Reasonable.
and then also, is that it, Member LaHood?
A successful application.
Oh, yeah, success. Yeah, but this would be the application, the successful application part. So you'd be working on a period of time for those successful applications, okay, as applicable in 6724, because it's pretty specific as to what needs to be made public. That's about it, I think, at this point. Would that seem reasonable to you?
It seems reasonable as long as we can come up with something that is a little bit narrower in scope.
That's okay. That's great. So let's start there,
Okay.
see how the process goes, and we'll take it from there. We still have a timeliness issue to deal with here, okay? So let's, thank you, Ms. Costa. So let's keep what we just discussed in mind as a possible solution, but let's also deal with the violation, if there is one. Don't ask me to lead this, folks.
Mr. Koskinen, you can come back up. And I think when you made your request, did they get back to you with some type of response within a day or so?
No. I believe they responded after business hours at maybe 7 or 8 p.m. And
The same day, the next day?
that was my original request. Just very simple, if they could give me copies of all email correspondence related to me.
Right, and when did they get back to you?
Let's see.
This wasn't an IDR, was it? Huh? Does it?
Part of it was an IDR.
Sorry, my apologies.
All right.
I have it somewhere.
Where do you see, where do you see that's an IDR? Oh, okay.
So they responded the next day
Okay.
at 7.
And what did they say?
They said, we need an extension, and then, which turned into a 2.5-month extension.
Okay, did they get back to you after they requested the extension with an update? This is what's happening.
I asked if they could provide records on a rolling basis, and they said, yes, we will provide records on a rolling basis, and then didn't respond for another few weeks and didn't provide the full response for 2.5 months.
And this is regarding the emails with your name in them?
Yes. So I think the whole city, DPH certainly uses Outlook. That should be a pretty simple search and filter, and there were not that many records, and I don't believe redaction would have been necessary, but that's up to them to decide, and it should have been a fairly simple request in my estimation with what I know.
I just got to get a little clarification here, because I'm looking at you have a graph, a grid with your timeline of communication that starts on May 13th, correct?
Yes.
Okay, but when I look at your request of May 13th, it just says disclosure request. It doesn't say immediate disclosure request.
The one up on the screen, there were 2 emails sent on the 13th to differentiate the immediate disclosure request from the regular disclosure request.
Okay.
Okay, got it. So I'm a little confused here.
So I see a response from them on page 692.
Yeah, but I'm a little concerned about the substance of what this whole process of it we went through. So if the complaint was on page 694 for the immediate disclosure request in 694, is that applicable to the items that are on page 693?
No.
Right. So on page 694, the immediate disclosure request is pursuant to the ordinance, please provide electronic copies of all correspondence regarding Alex Kostanen and this particular number, including all emails and documents written by DPH or any other city staff, including HRD staff, which I don't know what that is, I guess Human Resources Department staff by Tuesday. This is just information between regarding him personally. And Mr. Kostanen, is that the gravity or the focus of your?
So that was the original complaint. Back when I had filed it, they were still within the time limit for the regular disclosure request. I sent an email to Ms. Ledger on the 20th. You can see here that had the updated regular disclosure request information, and that I had sent in before the compliance committee meeting in order to get that on the record and included as part of my complaint.
Okay, so here's the thing. You filled out an intake form, correct?
Yes.
Okay. You noted that that the section that you're referring to is 6725 and various subsections, correct?
Correct.
Okay. This is in regards to an immediate disclosure request submitted on 5/13/2019. The request was, quote, immediate disclosure request, and so on page 695, that's the only request I see that says immediate disclosure request on it.
So both the immediate disclosure request and the regular disclosure request were discussed at the compliance committee meeting, and I asked if they could be merged, and the compliance committee and DPH seemed to think that that was okay. I asked if I needed to submit something separately, and I was told that no, both could be combined into one.
Okay. Committee doesn't have the authority to necessarily do that?
I don't think we said anything about combining. I think there was discussion about, and actually I don't remember if it pertained to this. We've had many conversations about having items heard on the same day. But that's, and I think I don't remember if it was this instance or some other, or a different one where you, in fact, I believe it was a different one where you, Cheryl, had explained that efforts are made to do that, but there are no promises, and that it's the chair's decision as to what items are heard on a particular day.
Yeah, was not put in front of me, whether to combine these to. Yeah, but in the microphone, please, so it's on the record. Thank you.
If what we're concerned about is timeliness, then whether or not these were technically combined or not doesn't seem to be dispositive.
But it's timeliness on which documents?
Well, timeliness on the immediate disclosure request, there was a timely response the following day, as I understand it. And then there was a subsequent.
I guess the issue I have is if somebody is petitioning for a violation against the respondent for a specific item, that's what we should be focusing on. And to introduce other items in the middle of a hearing is inappropriate. I'm concerned about that.
I understand. I guess I might ask whether or not timeliness is actually an issue in this case at this point.
Well, he started out with that summation is that he was concerned. That's what he's asking for now, essentially, is some sort of response from us regarding timeliness. So I see two different requests. I see a standard request, 6721 request, and then I see a 6725 request. His intake form is very specific. It's very lengthy. It speaks to the 6725 request. And everything that we've been discussing here has nothing to do with that. This is to do with other things, which regards to the other stuff. So I'm not inclined to allow it. Okay, do you understand what I'm saying, Mr. Costin?
So should I fill out a separate intake form for the regular?
I would say so.
Back through the process?
I would say so, and for this, for at least in this moment, I would say if we can quickly, so we don't have to do this again, if we can quickly adjudicate the 6725 request, which is on page 695, is it? 694. Let's deal with that, and so we can get to the rest of our agenda. So the original immediate disclosure request is, as I stated, it's very short. Pursuant to the Sunshine Ordinance, please provide electronic copies of all correspondence regarding Alex Koskinen and PBT-0931-092173, including all emails and documents written by DPH or any other city staff, including HRD staff, by 10 a.m. Tuesday, 5/14. Okay. This was on May 13th. Mr. Koskinen, with regards to this request, did you get a response from DPH by the end of the following business day?
Assuming that the end of the business day is 5 p.m. or 5:30, then no, I got it after 7 p.m. And
Okay.
that was a response that just said, we want an extension.
Okay. And of this particular information, did you receive any or all of this information?
I believe so. Approximately 2.5 months later.
Did they invoke an extension?
Yes.
And how long did they tell you?
There was no date given.
Okay. Thank you. Ms. Costa? I apologize for this, but so if we can keep the focus on this particular part, what information do you have on this?
I'll tell you that I have pulled emails in my organization, and it might be something that's easy to do in some organizations. It's not that
But what
easy
about
to
this
do.
particular information? Do you know if this information was given to?
It was, and it did.
Was it late?
It took time to get redacted. I don't know exactly how long it took to
Okay.
get everything to him.
And do you know if the department invoked the appropriate extension?
I believe every extension that we could invoke, we did.
Okay. And were you providing information to him on a rolling basis?
Yes, I believe so.
And Mr. Costin, you can just nod your head if that yes or no, whether they providing on a no. Okay. Not on an incremental basis. Okay. All right. All right. Thank you very much. Okay, members, let's pick it up from here.
The department responded the next evening at, 8 p.m., 7:30 p.m.?
You got a page? Or is that on his grid?
Yeah, I see it I see it in the record on...
Actually, I just scrolled past it. Hang on,
It's like a hi there, looks like an auto-generated thing.
page
but-
695.
Yeah, 695. So that's the next day at 7:18 p.m. I think he requested it May 13 at 8:30 a.m. or somewhere around that.
This is from the next request system that he was requested to use.
Right. Hi there, not able to respond pursuant to section 14 days. Then he asked for them to be sent all at...
And this response came at 7:18 p.m.
Correct.
So it was beyond the time, according to 6725, which is by the end of business, I think, right? Yeah, by the close of business on the day following the day of the request. I imagine the close of business is at liberal 6 o'clock.
Yeah, I mean, I think the only argument you'd have is that they were still working when they sent the.
Well, I think
They
what it
said-
means
but I
by
know-
the
I-
standard close of business is 9 to 5, right?
Right,
So,
I would agree.
You know, the building here for public access in general is 6 o'clock,
Yeah, so I
so
think,
to speak, so.
strictly speaking, it's a violation, but.
Okay. All right, and then they requested and invoked
Right.
an extension of 14 days, but 6725 limits it to only 10 days. That's in B. If the voluminous nature of the information requested is in a location, if the voluminous nature of the information requested, its location in a remote storage facility, or the need to consult with another interested department warrants an extension of 10 days, as provided by Government Code 6756.1, that's state law. The requester shall be notified as required by the close of business on the business day following the request. So they invoked the wrong period of time. Where is it? It's the other part here. And then in D, notwithstanding any provisions of California law of this ordinance in response to the request of information describing any category of non-exempt public information when so requested, the city and county shall produce any and all responsive public documents as soon as reasonably possible on an incremental or rolling basis such that responsive records are produced as soon as possible by the end of the same business day that they are reviewed and collected. This section is intended to prohibit the withholding of public records that are responsive to a records request until all potential responsive documents have been reviewed and collected. Failure to comply with this provision is a violation of this article. That was my question about the rolling part.
Yeah, I mean, on page 698, they say, "Hi, Alex, we're working with the city attorney to make sure that whatever, we redact what we needed to redact."
Okay.
So
You have enough information? Is there a violation here? Is there not a violation? If so, let's get a motion on the floor, and if not, let's do that. I'm being
Okay,
pushy.
I guess I'll make the motion again. From the strict interpretation, I think there's a violation for the response time in response to the immediate disclosure request. I don't think there's a violation regarding them producing them on a rolling basis. It seems like they were informing him.
Well, except I think he said, Mr. Costin, did you receive the first document quickly, or did you said something about it didn't come 2 months later? That's for this correspondence regarding you.
Yeah, they first provided a response on June 21st and finalized the response on July 22nd. So over 2 months to provide a single record.
So you didn't get the first record until June 21st?
Correct.
On this immediate disclosure request?
Correct.
Okay. Thank you. Ms. Costa, do you have any response to that or rebuttal?
I know that I saw at least in one of the packets 330 pages of email, so it's not really a single record,
Yeah,
I'm
but
just
do you know
putting
what
that
the
out
date?
there.
You know what the date is?
I don't know the actual date.
That it was delivered to him.
I do not.
Okay.
I can look back in the next request, but I do not.
Okay. Yeah, Member Yankee.
One quick question, because I know that's we talked about the close of business. What are the typical hours for your DPH administration who would handle this?
Well,
are working hours typically
I was just going to say that, Veronica's gone for these 3 weeks, and it's a lot of work. I don't know if you all are aware of how much work.
Well, no, I'm
Yeah.
getting back to the initial response. So the initial response is due by
Yeah.
close of business the following day, right?
So she
even if
works-
she's on vacation, you should have someone available to respond to these things. So someone being on vacation isn't. I'm just curious, so what are the typical working hours?
What I'm saying is she often works into the evening to get things done. Yeah, that's typical.
Yeah, but what's the standard working hours? I mean, if a person,
I call on the phone and someone would answer the phone.
yeah,
Well, we would say,
Are
8
you
to 5.
closed at 7 typically? If I were to go, at 7 o'clock.
The
and call-
building would be locked at 5,
Okay,
Okay,
so I would
so
say
that
that's outside
matters.
of, that's what I wanted to know,
Yeah.
on the
Okay.
record.
Thank you.
but we'd be working still.
Okay. All right. Member Martin, take it from there.
I mean, I still think there's a strict violation of the response to the immediate disclosure requirement.
6725A,
Correct.
and anything else?
Beyond that, I know you brought up the 10-day versus 14-day.
Okay, 6721 B, 6725B, I mean.
Yeah, violation 6725B. I mean, if there's nothing to produce on a rolling basis and they just have it all at once, I don't know.
Well, the testimony is that he did receive the information, but he received it almost 2 months later.
Right.
His
but
request was on May 14th, May 13th, and he didn't get anything till June 21st.
It's a long time.
Right, and if they had 10 days to produce something,
Well, I agree, but what they're telling him is we're reviewing it with the city attorney, we're trying to figure it out. If there's nothing to produce on a rolling basis because of that, and it takes 2 months, and then they release it all at once, I don't know.
but the ordinance that's the purpose of the rolling basis, is not to produce it, to do that and do it all at once. It's to, like, if you start today and you got through 5 today, well, you got to deliver the 5. Then tomorrow you do 10, you got to deliver the 10. That's the purpose of the rolling basis. And they're not to withhold it specifically, not to withhold it for all at once, to wait to the finish. So I'm just providing advice. So you can
I'd
think about what you want to do.
No, I agree. I think the part I'm struggling with is I don't know, if they're giving it to the city attorney, if they are really withholding it to give it all at once or not. You know what I'm saying? If they said, review this, city attorney held on to it, and then didn't give it to the department until all at once.
Well, it's speculation, so.
Yeah, well, I think it's speculation also to kind of say they withheld it. I don't know.
Well, if the petitioner didn't get the information, anything from them after that length of period of time, and with no response, it's like we're working on it, but then over a month goes by and nothing, to me, it sounds like, here on page 698, which was from May 28th. We are working together with the city attorney to make sure no sensitive, personal, confidential information be released with the responsive material that we have gathered in response to your request. As soon as our city attorney has finished their review, we'll provide you with the responsive documents. When? To me, that seems unreasonable, according to the ordinance. Ordinance is meant for expediency. It's not meant for, to provide some shelter to be able to hold on to documents until somebody thinks it's time to release it.
Right.
And then it doesn't seem like there's any. I mean, I don't necessarily have the whole thing. I guess. Okay, so here's something on June 21st. A message was sent to you regarding the request. Here are the responsive materials.
Right.
So I would just take it from there. May 28th
To July 22.
to June 21st.
So June 21.
Yeah, page 703. That was the next correspondence.
That's about,
I think, yes, that was the next correspondence. On June 7th, Veronica Veen, hi Alex, thank you for your email. I will input your request into our system. And note that it's in relation to, so from May 14th to June 7th, they didn't do anything. So let's take it from there. Okay, there's no requirement that it's got to be in the next request system.
right. We can add, we'll add that to the motion.
And they say, they admit it right there. We are not able to respond to your IDR today pursuant to 6725B and California Code Section CPRA 6253C. We're invoking an extension of 14 days. Well, that's incorrect right there.
Yeah, I mean, I think that's already part of the motion.
We need to consult with our attorney. We'll endeavor to complete a response as soon as we can. So, I mean, there are
Yes,
already...
then that we'll add to the motion the failure to provide the documents on a rolling basis.
6725D.
And that will be the motion.
Okay. Is there a second to the motion? So motion is to find a violation of 6725A on timeliness of the response, 6725B for incorrectly invoking the extension, and 6725D for not delivering documents on a rolling and incremental basis.
I'll second that.
Okay, moved by Member Martin, second by Member Yankee. Any other discussion or debate on the matter? Calling for public comment. Any public comment? Seeing no public comment, are we ready to vote? Seeing no objection, please call the roll.
Member Martin?
Aye.
Member Martin?
I said aye.
Member Yankee?
Aye.
Member Wolf?
Aye.
Member Wolf, aye. Member Tesfine?
Aye.
Member Tesfine, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay, and in addition, so both you folks, if you can get together and see if you can come at least on the other stuff. And Mr. Koskinen, if you do experience any other issues, or if you're free to file another complaint on the other issue, that's up to you. But considering we spent this much time in discovering all of this, it might be good faith to try to see if you can make it work. Okay, appreciate it. Let's call the next item.
Item number 8, reports from Sunshine Ordinance Task Force committees.
Complaint committee.
Complaint committee's been fine. We have one coming up November, I think, 17. We're dealing with, I think, a few more anonymous complaints. Not the same anonymous, a different anonymous.
There are different anonymous, specifically Mark Clark, I believe.
Correct. So that's something.
I think maybe I'm wrong about that.
And nor am I.
And I'll just note that in this section, I asked Cheryl if she would put all the minutes for those, the previous meetings leading up to this one, so you have it as part of the package, okay? And the public, too. All right, compliance and amendments, anything?
We did not meet.
Okay, great. EOT? Anything from EOT? No. Rules Committee? Is there anything from Rules Committee? No. And IT?
Yep. So we did have an interesting public hearing about metadata, because we had a lot of, the anonymous complaints dealt with it. We basically tried to narrow the scope of our discussion to number one, is metadata a public record? And then we heard a lot of concerns from the city that I think they brought up in the full task force hearing as well, talking about how if they were to miss one part of the metadata, that it would be, a huge security breach, and therefore, and it would be extremely difficult to go and redact it all, and therefore it should all be exempt. Is kind of the very short summary version of it. So we're going to try to get some more experts in and gather some more information to explore that issue a little further.
Okay, and yeah, it was my sense of that too, because this will have far-reaching effect in general, and we should at least get some advice and determine what kind of our general idea is for us, so it can be applied across the board as these issues come up. And this is kind of like way back when PDFs were being scanned as images and were not searchable, and the metadata was not retained. I believe former member and Vice Chair Rick Nee remembers that when we had some folks come in and explain it to us. So this is an important factor, and we've asked, I think you mentioned we've asked some folks to come in and try to help explain it to us so we can formulate some sort of standard.
Right.
Or
So we're looking,
baseline.
hopefully, cross our fingers, sometime in December.
Right.
So I'm waiting to hear back and see if we can get some.
Not in November?
It didn't
Think
sound
we're
like
ready?
November.
We're
Did
not
not
ready?
sound like that would be a doable time frame. The initial response that I got back was maybe December.
Okay.
And then then it was no, we're going to look for some outside experts. So that's where we're at now.
So the IT committee is going to meet in December
I would, if I hear back that some
experts?
experts can attend in December, I will
Okay.
let you and Chair Wolf know so we can.
Okay, because as it stands, the complaint committee would meet on the 17th of December. The following week is the day before Christmas.
Okay.
But, so we would have to put it off, I don't know, until January. I don't even know about that because we have to discuss the task force hearing
So
in January.
I think the issue needs to be addressed with Anonymous also. I mean, if Anonymous is not in any hurry to have these adjudicated, I think that it's incumbent upon us to make sure we're confident about how to even approach this, because it's not been easy with the
Right,
multitude of different kinds of things that the
Yeah, I think the
person's
same
been asking
question from basically for what we heard throughout the discussion is going to keep coming back as of, it's very technical.
Right.
There's security issues, and so it's kind of that weighing of security that
Redaction.
versus, what kind of redaction then? None of us are particularly experts in reading metadata and looking
Right.
and say that is redactable, that's not redactable.
Right.
When it comes to things like social security numbers, obviously those are concepts we can all understand.
So the other thing I would add on to it also, and DCA Peterson, Thorny, if you could maybe help us with that, is that something that you folks might be able to help us tackle on the metadata issue?
Sure. I mean, obviously, we've been dealing with a lot of complaints related to this. But yes, I'd be happy to work with.
Okay. That'd be great. And if you wanted to provide us, legal advice with however that comes to us, that would be excellent.
Yeah, if there could be any, if you could maybe do some digging and see if there's been any type of case law that deals with this. I noticed there's some type of reference to metadata on the Secretary of State's website, so that obviously it's come up in some regard, but I don't think there. Yeah, obviously that's not
The
a
League of
particular-
California Cities, I brought up in the last meeting, you might want to also dive into some of those organizations.
I know it's not applicable here, but I think it was Arizona had a Supreme Court ruling that several years ago that said it was public records, and so
Right.
obviously not directly applicable, but there is obviously that question that's been explored.
The other thing you can do is maybe pose a question to the Attorney General. See if maybe
That
they
might
have
be
it.
that might be a good route to take and see if we could get an opinion. Actually, yeah, if maybe we could work on something like that. I think that
Okay.
might be a good guiding way
All right,
to
great.
do this.
I have a procedural question.
Sure.
So I was under the understanding that information technology is an ad hoc committee, and I had expressed interest in attending and was allowed to attend. What I'm confused by is that there are people who are listed as members, and then in the record, member Hinsey, who's not listed as a member of the committee, was noted as present. I was listed as a guest. She was allowed to make motions, but not counted in the votes, and I was not represented anywhere in those. And I just want to understand what the procedure is.
Yeah, there are only 3 members of the IT committee, I believe, at this point. It's member Yankee, Vice Chair Wolf, and myself.
Okay, so
Ad hoc.
And it meets ad hoc.
okay, so
They shouldn't be
there are
hearing
a
complaints.
sorry.
They should not be adjudicating, it should not be doing complaints.
Okay, they did too.
We did,
Not
but then I didn't
supposed
get
to.
to vote on those because
Yeah, no, they're not supposed to. It was my understanding that there were going to be back-to-back meetings. That was my
And
understanding.
then that other one was canceled.
Okay, so let's not do that again. Yeah, IT committee is not a standing committee. So they can't, from the previous, the 2012 to 2016 process, which allowed for the standing committees, for any of the standing committees to hear complaints, that stands. The ad hoc committees should not be doing that. Yeah, Vice Chair Wolf.
It seems like if it's an ad hoc committee as opposed to a standing committee that meets ad hoc, then whoever is attending the meeting are the members of that instantiation of the meeting and should be able to fully
That's
vote.
what
and
I was
participate.
Yeah, okay.
So I
that's
should
your
have been
point.
able to vote.
Yes, you should have. I mean,
understand-
generally that's the case. We have asked people to, step up to be on the committees so they can meet, but, it's always an open invitation for people to show up. It's never been clear to me necessarily, because those ad hoc committees rarely had met, as far as how voting would work. I mean, the thing is, you can't have more than a quorum of the task force, or else it becomes a task force meeting, which demands some other process. So.
It was interesting regardless, but if my presence is not wanted or needed, I don't necessarily need more meetings in my life.
I'm sure there was no insult meant
No, my
memberhood,
understanding.
but
Excuse me.
we'll take that under advisement and consideration. Absolutely.
So just as a last note of clarification, the next time the IT committee meets, everyone who is a task force member who is attending that meeting, sitting on this side of the dais, will be able to vote and participate fully.
Yes, they
Great.
would, except it can't be more than 5 people.
Understood.
Yes.
Hold on one second. What if you have 4 and you have a split vote? I mean, isn't the whole purpose to have odd numbers? And I mean, I understand it meets ad hoc, but I think the committee is the committee. You have 3 members there. You have a chair that has to lead the committee. It's not just a free-for-all of who shows up. So that would be my position on that.
Member Vice Chair Josh Wolf.
I mean, we can dig into this further, but the role of the committee is such that the likelihood of 2 and 2 votes actually creating a conflict seems very difficult.
Let's work towards consensus, folks. Okay.
Yeah, if we're not hearing complaints, then I'm not really sure that there's, we didn't really,
Yeah.
we made a motion. There's not really no substantive votes anyways then.
Yeah, the question becomes, if we're talking about, let's say, this metadata issue, you come to a recommendation. I would hope that everybody's talking it through and there's, you come to some, consensus on what needs to be moved forward. It's a working group, more or less, so let's not make it too formal. Okay. All right, anything else on this cause? No. Okay, great. Let's see, what else? Any other committees there? No. Okay. Any public comment?
I'd like to hear what.
Richard Nee, apologies to the clerk. Before I didn't spell my name. It's Knee, just like elbow. Regarding the work of the ad hoc committee and the metadata issue, and I mean with this, no discounting or disrespect of the deputy city attorney, League of California Cities, or other the AG or other fine organizations and officials. But there are some other there are some sunshine advocacy organizations whose input the committee and the task force might want to invite. I think specifically of Californians Aware. Their General Counsel, Terry Frank, has drafted a model sunshine ordinance that is used throughout the country, including in San Francisco. Also, the First Amendment Coalition, whose executive director, David Snyder, is a former member of this task force.
I did reach out, just so you know, to the First Amendment Coalition. Have not heard back from them.
And you might want to also ask Freedom of the Press Foundation. Some very interesting people that serve on their board and work there. In fact, I heard a presentation from them today. It's very interesting. Okay. Seeing no other public comment, let's move to the next item.
Item number 9, Sunshine Ordinance Task Force Chair's Report. There
Okay,
are two
so
items.
at long last, because of some snafus here and there and timing, finally was able to get some response from both our representative seats on the task force here, and I was able to formulate a letter which I was going to send forward, sans having an actual vote to take a position. But since it was so close to this date, I decided to wait. And so what's before you is a draft of a letter to send to Supervisor Peskin with regards to the amending the Sunshine Ordinance under Prop B for the purposes of reassigning the nominating organization from New America Media to the Society of Professional Journalists of Northern California. I was very fortunate to have former Vice Chair of this task force, Rick Nee, who's with us today, in the audience, to help wordsmith this and kind of get it really solid. So I want to thank him publicly for that. I appreciate it.
To be clear, so we're referring to the paper document, not the link that was sent out previously, which is a different letter.
Yeah, this
Thank you.
this is an update. I'm sorry. Yeah, I should mention that. The one that I sent around was my original letter. This is the updated version. There was also what didn't get printed. There's a section that I wanted to review with you, but I do want to have it on the record for each of the representatives here that has gotten their information. If you could state what the response is from your organization on the record, and then we can determine, will help us move forward to officially take a position. I would appreciate that. Lila, you want to go for it? Oh.
Okay. So I brought this to the attention of the board of the League of Women Voters of San Francisco at our, I believe, September board meeting, and I was given direction that I could move forward in support of taking this action. Their position was that the voters have spoken, and was it Prop B? Yeah, Prop B is now the law of the city. So
Great. I think Lila's looking for her. Right. I can talk about something else while you're doing that. Okay, so let's see, where did I put it? Here it is. So there was a paragraph that that I had in there that Rick felt wasn't necessary. I wanted to just kind of toss it by you to see if what you folks thought. It's not in the paper. Somehow it didn't make it in the print. When it printed out, it didn't get that. It was because it was struck through using track changes. So I'm just going to read it, and if you think that it's not necessary, then we won't include it. If you think there's something there and you want to include it, then we'll have a discussion on it. This comes after the 4th paragraph. This would be the 5th paragraph. And it says, but to use the provision and authority to amend the Sunshine Ordinance without any reference to Privacy First, which is the Prop B charter amendment, seems questionable to many of the Sunshine Ordinance Task Force members. Despite that the Board of Supervisors has limited ability already to amend the Sunshine Ordinance as it has done so before, in this case, we have been informed and advised by legal counsel that adjustments of the nominating organizations constitutes a substantive amendment which must be approved by the voters. Rick had asked me at that point, when was that legal counsel brought forward? When we had discussed this, this task force had discussed it many times. We had gotten response from our legal counsel here, and I think Supervisor Peskin, when was asked about this, and a response from John Givner, who is the legal counsel for the Board of Supervisors, was also the same, that that's way too substantive. You can't just do it. So the question, for me, my point of this was just background. It may be, I don't know, maybe superfluous at this point, but that was the gist of my putting that in there.
So I found the email that I wrote to you, in which I said, so I consulted with the leadership of both the Society of Professional Journalists Northern California chapter board and our FOI committee, Freedom of Information Committee. As you know, SPJ NorCal opposed Prop B, but since it was approved by voters, we are in favor of asking the Board of Supervisors to use their new authority for amending the Sunshine Ordinance for the narrow purpose of reassigning nominating responsibility for the New America Media seat.
Okay, great. Thank you. So that is in response to the rest of the task force who asked you for that. So thank you. And that helps advise us on how to move forward. So with that, I present you with this draft. And Rick Nee's here if you have any other questions regarding this draft.
I think the draft looks good.
So it's really the second to last paragraph that's the meat of this, right?
Yeah.
Yeah.
And what I thought is that is our kind of the thrust, that's our position, and that if the Board of Supervisors does craft an amendment that second to last paragraph be, either the paragraph or the sentiment of the paragraph and the conditions be included.
Do we have any indication that they're going to accept this? Any advance?
I believe they will. They will. I found out about this in the hallway, and they were like, "Hey, did you know?" And I'm like, "No." I'm like, "No," but the Supervisor Perskin's office is motivated to do this. And because the other nominating organizations are also in favor of it, I requested that they wait until they heard from the task force. It's really also in our wheelhouse to suggest and request amendments to the ordinance as stated in the ordinance. So it would be appropriate for them to take our advice ultimately. So,
as far as the draft, I think it reads more succinctly with that part deleted.
Okay.
I kind of like with it out, but
that's fine. I just felt because
I see both. But I don't know. It's
fine. No problem. All right. Anything else? Any public comment?
Richard Nee again. One additional suggested edit in the excuse me, first paragraph, second line. There's a, I guess you'd call it a typo or a grammatico there, or a syntactico.
Where?
Okay, second line says helping us vacant task force seat.
With.
Cross out vacant and put in the words fill the. So helping us fill the task force seat.
Okay.
That does read better.
And on line 3, facilitated by voters' approval in November. That's
Maybe
There
that
shouldn't be
comma
no
should be-
commas offsetting 2018 because November and 2018 are not the same thing.
Right. Okay. Anything else? Oh, in the paragraph, in the second to last paragraph, there's that little convention that says SNP. That's a convention that I'm used to when you're taking something from a larger paragraph, like it's a sentence in the middle of a big paragraph. So I just put the word SNP to kind of notify the reader. Is that not necessary?
Not necessary.
Okay.
Sorry, just to go back to the very first paragraph. That one paragraph is just, it's one long sentence. I think it'd be cleaner just to say, the Sunshine Ordinance, et cetera, news organization, period. This process should be facilitated, et cetera. Break into 2 sentences. Just reads a little cleaner, doesn't change the...
I think it's a flow. I think
But
that second part of process, I don't know. I'll leave it up to better writers than myself.
I think Supervisor Peskin will understand what's being said in the letter.
I mean, there's paragraphs and dashes and parentheses that fall. It's just a lot of clunking together.
Yeah.
Being an English major just rankles me, but that's...
But it's also written kind of in constitutional construction in a way.
Right.
So.
I yield.
This needs to be put on our letterhead. I don't have our letterhead. If you want to send me our letterhead, I'll do it.
Yeah, I can do that.
Okay. That's great. Okay.
And make sure you remove all the track changes before.
Yes, of course. You mean he wouldn't want to see the comments? You know? Yeah, but I need at least our letterhead to.
Yeah, I can do that.
Yeah, then I can make it into PDF. Yeah, absolutely. Okay. Anything else for the good of the cause on that? Seeing no other public comment, I'd like to entertain a motion to approve this.
I'll second the motion.
So I guess I moved it. I was entertaining a motion, but that's okay. I'll move it, seconded by Member Martin. Anything else? Is this considered substantive? I would consider this to be substantive. This is an important factor.
Take a vote.
So let's call the roll.
Chair Wolf.
Aye.
Chair Wolf, aye. Member Martin.
Aye.
Member Martin, aye. Member Yankee.
Aye.
Member Yankee, aye. Member J. Wolf.
Aye.
Member Wolf, aye. Member Tesfaye.
Aye.
Member Tesfaye, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Highland.
Aye.
Member Highland, aye. The motion passes.
Okay, great. And Vice Chair J. Wolf,
Vice Chair.
not
okay.
member. Okay. Next item.
California Assembly Bill. That was included.
Member Yankee.
Sure, just an update here. There was a update to the California Public Records Act that was signed by the governor in October. Assembly Bill 1819, and I think it's attached. But the gist of it is really surrounding photographing public records. I guess across the state there are some counties or cities or whatever that objected to members of the public whipping out their cell phones and taking a picture of the public record, and instead insisting that people buy copies of it. And so this basically just clarifies that you can use your phone or other photograph equipment to take a picture of the public record, so you don't have to buy copies of it, as long as it doesn't damage the record or that you don't have unauthorized access to computer systems or whatnot. So
I'd also add that I don't know if people know that there is such a thing called the State Legislative Organization Committee here in the city. And this is the committee that hears about what state issues might be affecting the city and vice versa, what issues the city wants to have approved by the state legislature. And it's a all city employee, city official body, but it is listed in the compendium of committees that are out there, and trying to find a contact for that committee and get a regular report, either the minutes at least and their agendas. So, if there's anything that pertains to sunshine in either direction, that we have some knowledge of that. Because there are quite a bit of bills that pass through the legislature regarding CPRA and Brown Act and stuff like that, and other areas of law that that have to do with disclosure. So, the whole thing around the police records and whatnot. I don't think that was started with the CPRA. I think it started with the police code or some civil code or something like that. So. Okay, that's all I have on that. Let's go, any public comment? Seeing no public, let's move to the next item.
Item 10, staff report, complaints and communications. So I think my question about scheduling has been answered, but I just want to confirm. Okay, so November 26th, which is the Tuesday before Thanksgiving, compliance and amendments will meet? Is that a fair assumption?
I am available.
You're available, okay.
And
I don't want to be there alone.
We filled the former member Kanata's seat, right?
Not yet, no.
You haven't filled that yet? Does anybody want to serve on CAC?
Well, Fiona's on it as well.
So it's
Fiona and LaHoya.
Yeah, but we need one, should have one more.
I agree.
So is there anyone who's interested? No? Okay. Well, then Josh and I will alternate as needed.
Sure. When's the next meeting?
26th.
The Tuesday before Thanksgiving.
If you can't make it, I will.
I'll be driving south for Thanksgiving.
Okay. So I'll be here.
You'll be here?
Yeah.
Bruce.
You can throw me in the rotation.
Okay.
You guys-
Thanks. Member Highland offered to be in that rotation.
Awesome.
So,
Thanks.
great, appreciate that. All right, continue.
So we are not having an IT meeting probably until February after we've gotten more information from various.
February? No, it's got to be sooner than that. We're not waiting 3 months.
When do you
No.
want to do it?
January?
Or what about December?
It would have to be right before Christmas, was what Cheryl was saying.
Well,
Yeah,
you've got December 4th and December 17th, I guess would be the only.
we could,
Well,
I
we
guess,
have
look at it,
complaints.
doing it in lieu of complaints.
Could it
Yeah, but
or
except
could-
the ad hoc committee is not supposed to hear complaints.
Could it follow complaints?
Yeah,
Yeah, I could follow. If
Yeah.
we do a short complaints, maybe do it at 6:30 or something, or 7. We could probably,
Complaint starts at 5:30.
Does?
yeah.
That-
Can you
that
do-
change?
Can you do it before?
that's rough for me.
Rough for you,
Yeah.
okay.
Does EOTC have any slots?
Who?
EOTC?
Are there any other, do we have any other reserved space here in December?
No, we've only got
3 days?
Wednesday and then this third Tuesday and the fourth Tuesday. And the fourth Tuesday being the day before Christmas, nobody's going to meet.
Well,
Complaints, depending on the complaints, yeah, but depending on the agenda, we try to get that in under 2 hours. I mean, it depends on how many things are on the agenda. You know? I mean, if you could have something that goes from 5:30 to 7 for complaints.
Complaints used to
That's
be
just
at
a possible.
4:30.
I don't know. That's possible.
I could do that. I mean, I could come in at 7. That would work for me.
Okay. And we will need another person for complaints. We've only got.
all right, remember Kate's gone. All right, well, they'll put it into our rotation. So that's for December 17th.
The next complaint says November 17th.
Oh, I'm sorry.
November 19.
November 19th.
Sorry, November 9th.
November 19. That's the
I'm
next
sorry.
complaint committee meeting.
November 19th and December 17th.
Correct.
I can do December 17th.
November 19th.
So complaints is meeting monthly at this point, is that right?
I might be able to do, especially
I can't
the
do December.
19th. I'll see. I'll get back to you if
Okay.
I can.
The 19th
Great.
comes right
Well-
after complaints,
I'm saying I might be able to fill in for complaints and then just do.
and then
I-
just participate in
All
the
right,
next
take-
meeting.
Then we just continue with IT afterwards.
Yeah, okay, that'd be great.
When are we scheduling IT?
This is just just tentatively because I haven't heard back yet to see if anyone can come.
But
If, in fact, yeah, okay.
Yeah,
I
yeah.
highly doubt that they're going to be able to come that fast. Come to think of it, because the initial response that I got back from Dave was December.
So can you do this, can you do complaint committee on the 17th?
I think committee on. Oh,
And then have the IT committee at that time?
December.
In December, December 17th.
let's see. I don't think that will be a problem for me.
Okay. Why don't you communicate offline with Cheryl
Yeah,
and
yeah.
work it out? And then Josh will be off the hook for December.
Wait, but aren't we having
No.
Oh, the IT
meeting?
committee, right. So you'd be
Right,
here
that's
for
the
that.
day that I'm available. It's
Okay.
November that I'm not.
November, you're not. Okay, fine. And then
Makes
November? Can you make November, Chris?
Look,
Okay.
Okay, so
that's like now, isn't it?
Yeah, this month.
Where are we?
okay,
Today's the
so I
6th.
need to know if we're going to have new committee members.
So it's November
Well,
19th,
we're
right?
doing rotation right now for the empty seats.
All
People
right.
have not committed to,
Yes, I should be able to do the 19th.
I'm sorry, what'd you say?
Yes, I should be able to do the 19th November
Okay.
complaints.
okay.
At what time is it? 5:30?
Yes.
And then, well, have we put in, Cheryl, have we put in for, to fill the empty seats, the vacant seats yet, to the Board of Supervisors,
I
Rules
believe-
Committee?
We don't have anybody yet.
But has the announcement gone
I
out?
believe it has. I think
Okay.
Victor's worked on that.
Okay. Because that would be helpful, too.
Yeah.
All right, considering, what are we, 7 now? So, important quorum. Attendance is important
Okay.
for a full task force.
8?
Oh, we're 8? Oh, Hinsey, yes. Remember Hinsey, right? So we're 8.
Someone else leaving I didn't know about?
Yeah, no, that's right. 2 and 1 vacancy, yeah, okay.
All right, so what about the January Sunshine Task Force hearing?
Oh,
Since
so
the
that's
first-
January 1st. So
Yeah.
usually, right, we reschedule it. Usually it's the following week.
We can't get the room. I already checked to see if it was available on the 8th.
Oh, okay. Well, then,
Then we have to do like what we did in July.
well, here's the thing, if we do,
Or it doesn't happen?
well, what
That's happened as
happens then is that depending upon the number of complaints that comes in, then it's going to be double load for one committee, whichever day that is. Or the task force can meet as a committee of the whole and do the jurisdictions. And that's it, you only do the jurisdictions and not adjudicate those cases. Yeah.
Is the room totally not accessible on the first? Like, if we want to, can we? Or is it a
I think the building's closed, it's a holiday.
Asking the question, not be setting the answer.
Yes, it's,
If you,
July 1st is a federal holiday, it is closed.
if you throw a New Year's party the night before, I'll come. Spend the night.
We don't have to get here till 4 p.m. Most of us are not that hungover.
Okay, so 21st to the 29th, folks, while we have quorum here, please check your schedules.
Sorry, what was that?
The 21st of
21st.
January or the 29th of January?
21st might be hard for me. I should be fine with 29th.
You mean 22nd, 29th, right?
20
No, 21st and 29th is when the room's available.
Oh, when the room's available,
Yeah.
okay.
No, it's a Tuesday and a
then
Wednesday. Yeah,
Either of those is okay.
I'm okay with either one.
I can do the 21st, but not the 29th.
The 21st is right after MLK Day, just so you know. So that's a long holiday for some people, long weekend.
So 21st, 29th. Lila?
I can do either.
Either?
Either.
Either? Okay, so let's go with the 21st. Member Yankee will not be with us. Hopefully, Member Hinsey will be. We'll still have
If
quorum.
I can make part of it, I'll try to.
That's fine. That's fine. It just want to, the most. I've got to assure quorum here. So, okay. So, okay, great. So, we're going to do the 21st. We will do. I'll arrange on the agenda for part of the meeting to be a committee of the whole, the complaint committee. And we'll do all together, we'll do the jurisdictions and the 45-day stuff. And then we'll get to our regular agenda after. We're not meeting on the 1st, yeah. So you'll have 3 weeks, almost 3 weeks off.
And 2 meetings back to back.
Well, actually, since the task force, you'll be more than a month off. So, so there you have it. Okay, thank you. Continue.
Petitions and complaints submitted. They are all listed. Several of them are muck rock. Some of the anonymous ones are just private citizens.
Wait, did you just say some of them are what was the mug? What was?
Muck rock, that is the source
Rock,
of
that's
his
anonymous.
emails.
Oh, got it.
Anonymous.
Yeah. It sounded like some
IT.
Harry Potter language, and I was confused.
So does that mean that there are some anonymous and some muckrock anonymous, and those are
Correct.
designated
Yes.
appropriately? Okay.
Those have been separated out for a reason, so we know who they are.
Okay.
Petitions and complaints, we have succeeded in hearing all of 2016 at this point. 2017, those are Mary Miles issues, which will be scheduled for next month. 2018, we've got 5 matters, and in 2019, we've got a total of 52 that are blue, meaning that they are up for committee. That notice to respondents have been sent out. We're awaiting responses on many of those issues, and when we get them, we'll schedule them.
Okay. I just want to, on the pending issues, because a lot of these are with our legal counsel, the Mary Miles stuff, we need a response on that. If you can notate.
It's December. It's for
It
December
basically is our individual city employees who are the actual custodians of records required to appear before the task force, or can they be represented? Lots of times when a representative is sent, they are not fully informed or knowledgeable, and sometimes we want to have the actual custodian to answer details. And there's been some. It's actually was the last iteration of the task force that this came up. The response, one side of the debate was, it doesn't matter how the person gets the information, it's just that the information has been delivered. And on the other side of the debate was that the actual custodian, because the way the ordinance is written, as being an enhancement of CPRA directly to the individual, that the individual should be the one who is the respondent.
And I know that DCA spoke about this.
Can you give him the microphone?
We haven't provided you with any
No.
written memorandum.
No, and these been held off, and I'm trying to get through our, all our old cases. This goes back to 2017, so I want to, and it's more than one case. And it also is another one of those precedent-setting things because, everybody's looking for what the standard is or what the baseline is, and folks, will jump on that. Either side of the equation, they'll jump on it. So there's that. The other one is the Denta Tedeschi versus the City Hall Building Management with regards to the ADA and access issues. And what? And the sheriff, right, in the sheriff's office. So we need to get some response with regards to that. This involved his dog. They wouldn't allow his service dog in because he manages his dog off leash for particular purposes of, in his words, personal protection and whatever that need is for him. And he was prevented from bringing his dog in. His dog ended up being tied up outside, and then somebody called Animal Care and Control and had the dog picked up.
And does this relate to a particular
case?
complaint matter?
Yeah.
Which one is it?
Yeah, it's a long-standing case.
No,
This is the case where he was removed from one of the cable cars for having his dog on board.
Right.
And that whole thing, and he's, suffered, according to him, he suffered from it. So he's trying to get some information, and it's been very difficult. Yeah, right, and the sheriff's office goes back and forth. The sheriff's office won't take a particular position on this. They say, well, we're told by building management what to do, there's that kind of thing, so we're not quite sure. And then, they're being also being told by the mayor's office of disability, some various different things that are conflicting.
But he was before you a few months ago, on the issue of the guidelines for service animals on cable cars, and that didn't resolve the issue? No, okay.
I don't believe so.
Right.
I don't believe that we came to a conclusion on that. It's not, we weren't dealing with the access issues per se for that case.
Right.
We were dealing with the access issues for this building because he wasn't able to be here on time or at all. And on top of that, it created a somewhat of a what's the best word for it? Use
Source of anxiety.
Source of anxiety and possible intimidation for him to come to the meetings here in person. And it's his right to do that, especially in a government building. It's one thing if it was one Van Ness or something, which is a private building, but that shouldn't be the case here, especially when there's service dogs that come and go all the time. So we just need to know what the conditions were on it, and we couldn't get a straight answer at anyone. So, and then when he did come in, there all of a sudden the sheriff would show up. Why? We don't. He's never shown any kind of disruption. He's very courteous, and even though he's anxious about certain things, that's fine, but nothing out of the ordinary. Nothing that would, it's not being belligerent or anything like that. He's just, be a little out of sorts because of the gauntlet of what he had to go through. So, all right, that's it I have for that. Anything else, Cheryl?
I received 2 communications, one of them while I was gone from Anonymous Rock, that was included with this packet, and I received one from Ann Trabeau.
Okay.
Okay. And then requests from community persons. We received a lot between September 14 and October 25th when I was preparing this memo. 322 emails, phone calls, 322 emails alone.
Okay. Pretty cool. All right. Anything for Cheryl? No? Okay. Any public comment? No public to comment. Let's move to the next item. Any go ahead.
Item number 11, announcements, comments, questions, and future agenda items by members of the Sunshine Task Force.
Anything, folks? Nope. Any interest in folks getting out into the field and explaining to the public what we do? I do it kind of regularly to a lot of neighborhood groups. Call me and request. Huh? Yes, I did it for Prozac.
Where was it?
At McLaren Lodge. That's where
That's
they
my
meet.
neighborhood, so
Yeah.
some of my
I live-
neighbors are in it.
I live across the street from McLaren Lodge. And so, yeah, I was there. They were very, very interested because they are somewhat marginalized from the Rec and Park Commission. And so they wanted to know, like, what authority do we have to, and, so it was very interesting. It was, they had a completely different view. They were like, wow, we can do that. Oh, yeah, absolutely. So it's interesting, and I've done it with a number of neighborhood groups. I did it for Cheryl's Partners group over in the Richmond. So people should know that this is resources available to them. And in past years, we've made up brochures that you can just hand out, and things like that. If there's any interest you want it around promoting things like that. Also, the ordinance encourages our somewhat enterprise or state bodies to adopt the Sunshine Ordinance, like the Unified School District, City College, various other entities that are home base here, focus on the city, to adopt and abide by our Sunshine Ordinance. Not that they do, but it's always worth to, hammer them here and there, because they just follow the Brown Act and CPRA, which sometimes is not enough. So
I actually have 2 questions. I'm trying to remember. Last year we had like a retreat day.
yeah,
Did that happen in the beginning of the year or in the fall?
January.
January. Okay. So
we should think about doing that again.
Right.
Yeah.
So that was one thing. And then the other question is, with all the openings that open seats we have, how are we promoting those? And are there links to list? Like, do we just tell people, or can we actively promote and try to recruit? And what's the process for that?
If it's promoted, it's listed on the Board of Supervisors website under vacancies, and there's a menu item for vacancies. And I'm sure there are a couple other places that's listed. It's probably posted in the library, but probably nowhere else.
So are we encouraged to promote? Are
absolutely.
we asked not to?
No,
or-
no.
Okay.
Sure. I don't see why that should be. a
I'm all
problem.
about marketing.
Yeah, or if there's any standardized language that you could circulate for us to,
That would be helpful.
what is that, nextdoor.com? I could put it on there.
Yeah. I think if you just grab it off of the Board of Supervisors website on the vacancy list, it has a whole narrative that's in there. It's not that long. And you can also provide the link. I think that's enough. And then just give your own blurb, be part of, one of the few people's courts in the city, or something like that, or, make a difference, community run, oversight or something like that. I don't know. Just throwing it out there. All right. Anything else on this? Should we move to the next item?
Item number 12.
Oh, public comment. Seeing no public comment. Next item.
Item number 12, adjournment.
Motion to
Those
It's
cops
fine.
were coming for you when you didn't call public comment.
Is there a motion to adjourn?
I think we should wait till 8.
Second.
Move to adjourn.
Second.
Moved by Member Yankee, second by Member Martin. All those in favor say aye.
Aye.
Opposed? We are adjourned. Thank you.